All right. Good morning, ladies and gentlemen. My name is Judge Lal, and we're going to begin with our state all-purpose calendar. This is a misdemeanor calendar with the State Court of Fulton County for today, May 23rd. Does that sound right? Yeah, May 23rd at 9 a.m. These are cases in which individuals have misdemeanor cases have already been formally accused. And today we're going to get a status of the case. If you're a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you choose to say during the course of these proceedings, which are not only being recorded but live streamed, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. We have counsel from both the Public Defender's Office and the Conflict Defense to represent you. All right, for individuals who are not an attorney, could you please keep your video off? You can start your video when you hear the defendant's case whom you're interested in addressing on. So, Ms. Vigiletti, good morning.
Good morning, Your Honor.
And who are we beginning with?
We're gonna start AC/DC, Your Honor.
Okay, sir. All right, and there they are. All right. All right. Who is at AC/DC, please?
Hey, they're calling us.
The deputy at AC/DC?
I'm Judge. I was down at the other end. I'm right here, Judge Law.
Oh, there you are. Good morning. Yes.
Good morning.
Okay. How are you? Okay. Who are we going to begin with?
I have position 5 and 6. Mr. Jones, it says a negotiated plea.
All right. Thank you. All right. We are addressing Mr. Jermaine Jones or Jermaine Jones. He's got two matters before us. Position 5 is case number 24 CR 1772E, in which Mr. Jones was accused of shoplifting and criminal trespass, both misdemeanor charges, from August 31st, 2023. Mr. Jones, you have a second case, 24 CR 3064E, in which you have another two counts. One is theft by shoplifting and the other is criminal trespass from September 4th, 2023. You have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. May I place you under oath for purposes of the plea hearing? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no.
Yes.
Thank you. All right. Ms. Falk, what's the recommendation for Mr. Jones?
Yes, Your Honor. The state's recommendation is on count 1, 12 months probation, serve 158 days, credit for time served 79 days. That is from September 4th, 2023 to today. Balance probated, $500 fine, anti-theft course, stay away from 4735 State Route 138 in Union City, 40 hours of community service. On count 2, the criminal trespass, the state's recommendation is 12 months concurrent with count 1. Position 6 is again theft by shoplifting. It is the same recommendation as position 5. We're doing 12 months serve 158, credit for time served 79, stay away from the Walmart at 4735 State Route 138 in Union City. That is to run concurrent with the case ending in 1772E. Count 2 will run consecutive to count 1 of criminal trespass. So we have 24 months, serve 158 days, credit for time served 79 days, a $500 fine, an anti-theft course, stay away from the Walmart at 4735 State Route 138, and 40 hours of community service. I will say that based on the defendant's criminal history, those fines are statutory. I do recognize that PD Vigiletti is going to ask those to be converted into community service, but our recommendation was based on a statutory fine for previous theft by shoplifting convictions. That's all for the state. We would ask Ms. Vigiletti to stipulate to venue factual basis and identification for the purposes of the plea. Thank you.
Thank you. Ms. Vigiletti?
Yes, Judge, we do stipulate for the purposes of the plea, and I do want to ask you this morning, Mr. Jones is a chronically homeless individual. We had a long talk yesterday about kind of everything that needs to be done when he gets out of the jail, which involves securing housing and a job and really starting over as early as tomorrow. And he's motivated. I think he has a good plan, but between the $500 fine and the probation fees, you know, it adds up. And Mr. Jones has more immediate knowledge of where to do community service than where to get a job. And so I did want to ask you this morning, Your Honor, if you'd be willing to convert that fine to community service.
He will be required to do 20 hours of community service and pay a $300 fine. And every month he will report to probation as to his attempts to secure employment. He would need to bring at least the names and addresses of 4 businesses that he has approached in order to seek employment every month. I will waive his probation fees for the first 6 months. He'll have to report every month for the 24 month that he's on probation.
Understood, Judge. Thank you.
So he has 6 months to get a job in order to make sure that he continues with probation. Otherwise, he could be looking at a revocation.
Understood.
All right. Mr. Jones, and I'm so sorry, Ms. Vigilante, you did say a yes to the stipulations, yeah?
Yes, Your Honor.
Okay. Mr. Jones, have you consumed any medicine or alcohol?
No, I have not.
And have you understood the proceedings so far?
Yes, I have.
You understand that you will be on probation for up to, I want to say 18 and maybe 19 months.
Yes, I understand.
All right. And you'll need to stay away from not just the Walmart at Union City, but you're going to stay away from all Walmart stores.
Yes, I understand.
All right. And are you satisfied with your legal services?
Yes.
Is anyone forcing you to take the plea today?
No, ma'am.
And if you decide to enter into this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court and confront your accuser, challenge the evidence that would be brought against you, present your own defenses and mitigating factors if you choose to do so, and also have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of theft by shoplifting and criminal trespass at Walmart from August 31st, 2023?
Plead guilty.
How do you plead to 1 count of theft by shoplifting and criminal trespass at Walmart from September 4th, 2023?
I plead guilty.
For the August incident, your sentence is going to be 12 months to serve 158 days, credit for time served 79 days. You will be released and you must report to probation on Monday, which is going to be May 20, I want to say 27th? 27th, yes, that would be correct. May 27th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will pay a $300. You'll pay a $500 fine. Your $500 fine is now going to be converted to a $300 fine, and you would need to make a minimum payment of $10 per month. After that, you need to complete 20 hours of community service at any nonprofit agency, and that cannot be a church and it cannot be a school. It can be any other nonprofit agency, but not a church and not a school. And you must complete a minimum of 20 hours of voluntary community service, beginning with 5 hours per month and a minimum of 5 hours thereafter. Count 2 on criminal trespass from August 31st incident will be concurrent to count 1. And as I said, to stay away from all Walmart stores. I completely missed that one. Miss Falk, you did ask for an additional 40 hours of community service, right?
I had, Your Honor, yes.
Okay. So that means his obligation for community service is 40 plus 20, that's 60 hours.
Okay.
60 hours of community service. Okay. With regards to position 6 on count 1 theft by shoplifting, that would be concurrent to the shoplifting sentence from the previous case. Again, to stay away from all Walmart stores, report to probation, and pay your fine and do your community service, minimum 60 hours. With regards to count 2 from the September incident, this will be 12 months probation consecutive to count 1, which means that after you finished the first set of probation, you will begin another set of probation. And again, you will report every month. In order to make sure that you are up to date with your probation fees as well as paying your fines, you are required to diligently pursue housing and employment. So every month that you go to probation, you will give them a list of at least 4 attempts where you've tried to secure employment and housing. Hopefully, those attempts will be successful so that you can stop and you will be secured with housing and employment, because after 6 months of probation, you'll be required to start paying probation fees.
Understand?
Thank you. If you get arrested again, if you fail to report to probation or you violate any of the other conditions, such as going back to Walmart, probation has the authority to revoke your probation and have you serve out the rest of the time at the Fulton County Jail. Thank you.
Thank you, Judge.
Next, Judge, we have position 11, McPherson.
Thank you.
Judge Law, can you check your chat, please?
Okay. Oh, thank you for reminding me. We're so busy working, we completely forget. Mr. Jones, your probation report date is Tuesday, May 28th. Monday is a holiday. Thank you.
Holiday is Monday.
Monday, May 27th is Memorial Day holiday, so you report to probation on May 28th, a Tuesday, before 3 p.m.
Yes, ma'am.
Thank you. All right, we have Miss Alexis McPherson, middle name Diane, case number 17 CR 0213948. Ms. McPherson, you've been advised of your right to remain silent, and your attorney is going to be Ms. Vigiletti. Ms. Vigiletti, with regards to position 11, how are we proceeding?
Yes, Judge, I only have an accusation for this case, and unfortunately, it is a 2016 case. Ms. McPherson, when I went to talk to her about the incident, has absolutely no idea what I'm talking about. So I am requesting this morning, she'll be here for another matter until at least June 6th. So we do have time if we need to reset and just get some documents, a citation, a police report, something. Just because if she doesn't know what we're talking about, of course, we can't resolve this.
All right. It looks like it was a driving without a valid license and operating a vehicle without a current license plate and decal from May 19th, 2016. Ms. Falk, do you have any documentation other than the accusation?
Your Honor, we requested documentation from, this case was bound over from Atlanta Municipal Court, so we did request documentation from the municipal court so that we can proceed on this case. We have not received that yet. I requested it 2 days ago and then requested it again yesterday, but I have not received it as of yet. I will say that the primaries could have stymied some of that, so I expect to have it by next week.
All right. And Ms. Vigiletti, what's the other matter holding Ms. McPherson?
It's a felony matter, Your Honor.
All right. We're going to reset this to Thursday, May 30th. I don't think I'll be doing the SAP calendar at that time. So Ms. Vigiletti, please make a note that if no other paperwork other than accusation exists, the case is going to be dismissed.
Okay, thank you, Your Honor.
All right, moving on. Ms. McPherson, we are going to see you again next Thursday at 9 a.m. and your attorney will advise you as to update of the case. Thank you.
Okay, you're welcome.
Is there a conflict attorney available?
I'm sorry, Sergeant, what was that?
Ms. Wilkie, positions 20 7 through 31. She's a conflict, is one online.
All right, do we have a conflict counsel? All right, no, was that a no?
I believe Ms. McLeod is here.
Miss Maureen McLeod? I don't see her on the Zoom.
Oh, I see her picture, but I don't see her.
Oh, there she is with the bookcase.
Yes, Judge.
All right, Miss McLeod, good morning.
Your Honor.
Yes.
I was trying to get my my audio on.
Okay. And what position number was that again? I believe.
It's Miss Wilkie. She's position 27 through 31.
All right. All right, Miss McLeod, is that your client?
It is my client, Your Honor, and I must let the court know that I have not had an opportunity to speak with her yet.
All right. Sergeant, do we have anyone else to address at Fulton ACDC?
Yes, we have one that's on a probation. She's position 1 and 2, Miss Brown.
All right. Is there a way that Miss McLeod can call your location?
Yes,
Otherwise, I can put her in a breakout.
yes. Can we do Miss Brown, then put them in the breakout room?
Yes, we can do that. Thank you.
Thank you.
And our probation officer, Miss Allen, good morning.
Good morning, Your Honor.
Okay. This is a probation revocation case involving Tonya Brown. Miss Brown, my name is Judge Law, and first of all, I'd like to remind you that you've been advised of your right to remain silent, and your attorney is going to be Miss Vigiletti. Do you see your attorney on the screen? No, good. Miss Tonya Brown has a probation revocation matter for a case reference in position 2, 21 CR 007787D, in which she was convicted of one or more of the following charges: reckless driving and failure to maintain lane or improper lane change. Her probation revocation case is 24 PV 840. Miss Allen, if you don't mind raising your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Miss Brown, the oath actually applies to Miss Allen, so. Okay, Miss Allen is the probation officer, and she is going to tell us what were the convictions and what were the requirements and why they're seeking a revocation in your case, as well as the recommendation. Miss Allen?
Your Honor, the defendant was required to report to probation for the charge of reckless driving. She was ordered to complete 40 hours of community service, complete a drug and alcohol evaluation, risk reduction program, victim impact panel, and pay a fine. The fine totaled to $1,010.50. As of today, the defendant still has a balance of $884.50. She's failed to provide documentation of the 40 hours of community service. She's failed to provide proof of the DUI school. She's failed to provide proof of the substance abuse evaluation, as well as the victim impact panel. She was ordered to appear before Judge Etline on July the 25th of 2023, which she failed to appear. Your Honor, it is 43 days remaining on her case. And at this time, probation recommends that her balance be revoked.
All right. Miss Allen, do you know how many days she's already been in the jail?
I was actually getting ready to pull that up as we speak.
Thank you.
10, Judge.
I'm sorry, Miss Vigiletti, what was that?
Day 10, she was booked in on the 14th, so this will be her 10th day here.
10th day, all right. All right, Miss Vigiletti?
Yes, Judge, I spoke with Ms. Brown and, you know, I understand she has not done a perfect job on probation. She did tell me she had a very serious injury in the last year. She was holding a baby and she fell and severely injured her shoulder. And, you know, she said she did communicate that with Officer Charlo. There should be documentation of her. She couldn't drive, she couldn't move, couldn't do much of anything. She says she forwarded a letter from her doctor at Emory to the officer to kind of explain, you know, she did make some payments on her fines. And, you know, of course, at this point, she served 1 day in jail when she was first brought in and now has just served 10 more days. So we are asking for time served today to cut this a little bit short and give her time served. She runs her own business. She's lost out on some pretty significant sales in the last 10 days. She runs a body care product business. She also has 4 young adult children who, you know, of course, still need her 19, 23, 26, and 27. And, you know, understood that, you know, she did not do a perfect job at this probation. Some mistakes were made, but, you know, when I went to see Miss Brown, she actually already had a plan laid out where she wasn't blowing probation off. She was like, I had this injury, but I could maybe make some payments and I could do this and I could do that in the next few months. And, you know, she wanted to make this right and get this done. So, we are asking this morning, Judge, if you would, be willing to cut this jail time 12 days short and give her time served.
And Your
yeah,
Honor,
sorry, Ms. Allen.
she did in fact notify our office of her injury and the document was received. That is why she was set to go before Judge Edline to deal with that matter, to possibly waive some of the conditions, but she failed to appear for that hearing. So that's why we're here today.
All right. Any follow-up from that, Ms. Fischletti?
I'm sorry, Judge. This is completely my oversight. I did not notice that she missed a court date, and so I did not ask for any questions. I'd be happy to speak with her about that briefly.
Okay. Yeah, that seems to be the big question right there. After the injury, she was given one opportunity and she failed to take advantage of it. So now we are here on her complete and blatant failure to comply with probation, at least since July of 2023. So, all right, you may contact ACDC because I'm going to place ACDC into a breakout with Ms. McLeod.
Okay, Deputy, could I give you a call, or could you give us a call?
Well, I can't. I have, the ladies that's on felony on the other phone interviewing. So it has to be like a breakout or something, because I don't have another phone.
Otherwise, I can reset it to next Thursday.
I'm sorry, Judge, we're having a logistic issue here because the jail has stopped letting me bring in my phone.
Okay.
And,
Let's put Ms. Brown on hold, and with the host, Sergeant, we're going to put ACDC in a breakout session with Ms. Maureen McLeod. Ms. McLeod?
Yes, Your Honor.
Yes, I'm going to put you in a breakout session with Ms. Wilkes, please.
Yes, Your Honor.
All right. And please, courtroom 2, who shall we address now?
We're gonna stay on the probation calendar and
Yes,
go
sir.
to position 3 and 4, and this is Mr. Vincent Price.
Thank you, sir. We have State versus Vincent Price from our probation revocation list of cases. Mr. Price, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. With regards to your probation case, on position 4, you were previously convicted of simple battery in case 23 CR 000044D. And it appears that you were placed on probation. There have been alleged violations, and there is a intent to revoke your probation. Your probation case is 24 PV 813. Ms. Allen, you've been previously sworn. What is the basis for the revocation?
Your Honor, first I need to make an announcement with Mr. Vincent's case. We realized as I was preparing the case, he actually has 2 cases with 2 warrants. We also have him, and I spoke with Mr. Jordan on yesterday, but we also have a case 23 CR 000891D.
891D. And is there a PV case with that?
Let me see. Give me 1 second, Your Honor.
What is this probation case that holds on the probations that I got?
yeah, she's about to.
Okay, and that's 23-002-700 PV.
24 PV 002.
I'm sorry, 23-002-700 PV.
700 PV. Okay. And that is related to the 891D case?
Yes, Your Honor. And I think what the
I'm sorry, Miss Allen, your Wi-Fi. Oh,
Okay.
Miss-
Your
Mrs.
Honor, can you
Allen,
hear me? Can you hear me?
now I can. Your Wi-Fi
Okay.
was just going in and out just
Yeah.
now.
I'm on the office Wi-Fi. I just took myself off.
Okay.
But yes, I think the confusion is a Vincent and is a Vincent, but it's the same person.
Oh, Vincent and Vincent, common spelling?
Mhm. Yes, the Vincent for the 891D is VINCENT Price. And for the 044D is a Vincent, is VINSON Price.
Can you confirm that the date of birth are the same?
So that's the thing. So the confusion also with Mr. Price, when the file was sent over to our office, they sent over, give me 1 second. So for the 044D, we have his date of birth as 3/23/64. And for the 891D, we have 2/23/64.
Okay. Ms. Vigiletti, are you aware there may be another open case against your client under the name of Vincent Price?
Yes.
I don't know. I'm not saying, I'm not establishing that as a fact. I'm just saying there appears to be.
Yes, understood. I became aware yesterday afternoon when Miss Allen reached out with her recommendations. She did share the warrant with me this morning on that additional case that ends in 891D. My concern is that that warrant has not been served on Mr. Price. So when he got to the jail, of course, the other warrants were served and that was not part of it.
Okay. I just want to make sure that. Mr. Price, would you please lower your mask? All right, thank you. You may replace your mask. Thank you.
I did confirm the spelling of his name, Your Honor, is VINCENT, but he was aware that it has been misspelled in the system in the past.
All right, so I'm looking at his booking pictures from both cases and it is the same individual.
Yeah.
So I'm satisfied that both cases apply to him. I can reset the case to to have all 4 cases reset to next Thursday, during which time Mr. Price can be served with the second probation warrant, and we can address both his cases and both his revocation matters.
Judge, I do have the warrant, and I know that Ms. Allen's recommendation is to continue. I'm happy to present him with that warrant if that's.
Is your client prepared to waive service on the second probation warrant?
And I would have to discuss that with him briefly.
Okay, so if you want to mute your screen, otherwise we are prepared to. Well, let me ask Ms. Allen, are you prepared to address both cases, Mrs. Allen?
Yes, Your Honor, I am.
All right. All right, while we are waiting on Mr. Price, Ms. McLeod, are you ready to proceed with Ms. Wilkes?
I am, Your Honor.
Okay. We are going to take a pause on Mr. Price's case and address Jennifer Wilkie, position 27 through 31. Ms. Wilkie, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod with regards to your cases. Position 27 begins with 23 CR 432C, in which she is accused of 2 counts of giving false information to an officer from December 17th, 2022. The second case is 23 CR 433C, accused of theft by shoplifting from November 16th, 2022. Third case, 23 CR 2893C. She's accused of criminal trespass from May 10th, 2023. Fourth case is 23 CR 4726C. She's accused of criminal trespass from July 31st, 2023. And the fifth case, 23 CR 5796C. She's accused of criminal trespass from September 23rd, 2023. That's a total of 3 counts of criminal trespass, 1 count of theft by shoplifting, and 2 counts of giving false information to an officer. Ms. McLeod, how would your client like to proceed?
My client would like to enter her not guilty plea to all of these cases, Your Honor.
All right. Will you be filing a waiver arraignment? Or...
I will be filing a waiver of arraignment in all of the cases and request that she has a trial for all of them.
All right. Ms. Wilkie, your attorney, Ms. Maureen McLeod, will be entering a document that we call a waiver of arraignment and essentially entering a not guilty plea on your behalf. All 5 cases will be further notice for trial with the division judge, and you will get notice as to when to appear for court. Thank you.
Thank you, Your Honor.
Thank you.
And Your Honor, I believe that concludes my business for this part of the calendar. I do believe I have a client on the competency calendar.
I will see you at about 11-ish.
Yes, Your Honor.
Okay, all right. Thank you.
Thank you.
Ms. Vigiletti, you have a client that you would have to address at probation, but please let me know if you're ready to proceed on the Price case. I'm so sorry, Ms. Vigiletti, you have a client ready at ACDC, and if needed, I can reset Mr. Price's case next Thursday to address this matter.
No, I'm ready.
I apologize, Judge. Yes, Mr. Price is ready to address these two probation issues. He is prepared to, waive service of that additional warrant.
All right. So with regards to the probation revocation warrant under 23 CR 000891D, Mr. Vincent Price, with a date of birth of February 23rd, 1964, do you waive service of the revocation warrant?
Yes.
All right. Please raise your right hand, sir. Other right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. You have 2 cases with the State Court of Fulton County in which you were convicted. The first case is Vincent, V-I-N-S-O-N, Price, common spelling, 23 CR 44D. And then you have a second case, 23 CR 000891D, in which your name is listed as Vincent, V-I-N-C-E-N-T, last name Price, with a date of birth of February 23rd, 1964. Is it your testimony that you are one and the same person in both cases?
Yes.
Okay. And what is your correct date of birth?
3/23/1964.
All right. So on the 891D, we need to correct that to reflect that his date of birth is March 23rd, 1964. And what is the correct spelling of your first name?
Vincen.
Repeat slowly, please.
Vincent, Vincen. Edward, Price. Vincent Price, but they put a T on it. So,
So it's Vincent with no T?
no, Vincent. Vincent Price, not Vincent, Vincent.
They both sound the same to me. I'm not very good at spelling, so I'm going to repeat this. Is it Vincen?
Yes, Judge.
Vincen, not no T on it. Vincen.
All right,
But I go by T, I go by Vincent.
I don't care what you go by. I want to know what is your legal
Birth
name.
certificate is Vincen.
Okay, thank you.
Cool.
All right, Miss Strong? We will need to send a note to correct the jail records in both these cases, as well as the probation revocation matter, that he is also known as Vincen, Vincen, Price, Price, and the correct date of birth is March 23rd, 1964. All right, Mrs. Allen, with regards to his probation revocation matter in the case 23 CR 44D, what was he convicted of and why is the state seeking a revocation?
Your Honor, the defendant was charged with simple battery. He was required to do 6 weeks of anger management classes, as well as have no contact with Tanya Harris. All probation supervision fees were waived. As of today, the defendant has failed to provide our office with completion of that anger management course. And he has 82 days remaining on this case. Your Honor, because of the time frame, probation is asking for him to be allowed to continue on probation, but with a deadline to start on those classes within 1 week of being released from jail.
Understood. And what about 23 CR 000891D? And
He was charged with simple battery as well as criminal trespass. He was sentenced to 12 months. He was also required to do 6 weeks of anger management classes, have no further contact with Ms. Garrison. All his probation supervision fees were waived. He also was ordered to stay away from the incident location. And this particular case is actually 136 days remaining on his case. So he has enough time to complete those conditions.
so he needs to complete a total of 12 anger management classes and stay away from Tonya Harris and Miss Garrison. Would that be correct?
Well, he was originally ordered 6 weeks of anger management. So are we changing it to 12?
Well, 6 weeks for the first case and 6
Oh,
weeks
6
for the second case.
Okay.
Would that be
Okay.
correct?
Well, normally if it's 6 weeks, we just do a straight 6 weeks of classes. I mean, we don't require them to do 6 for both because they're concurrent cases.
Oh, were they convicted at the same time? Okay, understood. Thank you. Miss Vigiletti?
Yes, Judge, I spoke to Mr. Price yesterday, who told me he has been in Clayton County Jail for most of the past year. I did reach out to Clayton County. I did not get a formal proof of incarceration, but what I did get is plea paperwork from just right before he arrived here on May 10th that acknowledges he had spent 250 days in the jail. I'm happy to turn that into Your Honor and you as well, Ms. Allen, if you'd like. But you know, of course, after having spent almost a year in jail, he didn't have much opportunity to work on this probation matter. But you know, of course, we agree with Ms. Allen's recommendation to allow him to continue on, give him a chance to get that done. So we just ask that you accept her recommendation this morning.
On the case 23 CR ending in 44D, we'll give him credit for the time he's been at the Fulton County Jail, and that would be. Do you have that information, Ms. Vigiletti? Otherwise, I'm just going to
Yes.
jailings,
He was
which tells
booked
me 17 days, correct?
I believe he was booked in May 10th.
Oh,
I may be wrong.
no, you're correct. I was looking at the older case. May 10th, so he's been in custody now for 13 days. Would that be correct?
Yes, Your Honor.
Okay. So, Mrs. Allen, on position number 4 on the revocation calendar, with regards to Mr. Vincent, Vincen Price, also known as Vincent Price, Vinson Price. We will continue him on probation, give him credit for 13 days, and he will report to the probation office on Tuesday, May 28th at before 3 p.m. And that probation office is located at 132 Mitchell Street. And he will report every week. So as his probation fees have been waived, I will maintain that provision, but he will have to report once a week. He must begin his 6 weeks of anger management classes for that cases within 14 days of being released. And that means by his 3rd probation visit, he must show proof that he is enrolled in taking his anger management classes. And he will continue to report every week until the first set of 6 weeks of anger management classes are completed. And he is on probation for 82 days with regards to that matter. So he will continue to report for 82 days. So that will be 82 less 13 days. That would be for 69 days. Would that be correct, Mrs. Allen?
Yes, Your Honor. So let me just make sure, because I'm writing all this down. So on case ending in the 44D, he will be given credit for time served where he's required to do the 6 weeks of anger management classes.
Right.
He has to report every week. He's to report, you had the 29th?
The 28th.
28th, I'm sorry.
Tuesday.
Okay. Okay.
You're laying down.
All right. And he'll need to finish his first set of 6 weeks of anger management classes.
Okay.
All right. After he has completed the first set of 6 weeks of anger management classes, he's going to be required to do another set of 6 weeks of anger management classes for the 891D class. And thereby his probation, once he's completed the first set of 6 weeks, his probation may be amended to once a month. And that would continue until the 136 days left on the 891 case is completed. So he will be on probation for up to 136 days, less 13 days. So that's a total of 12 weeks of anger management classes and to be on probation for 136 days.
Okay.
Do you understand, Mr. Price?
Yes.
All right. Please be aware that if you miss any of your probation appointments, I don't care whether you are, if you miss an anger management, but if you miss any of your probation appointments, if you are arrested again, please use the phone at the facility to make sure that your probation officer knows that you are currently detained at some other facility. But otherwise, you are required to report every week, and then your probation officer will let you know when your reporting requirements will be amended to every month.
Yes, ma'am.
And you are required to do 12 anger management classes.
So when I get out between the day, go down to Hayville.
Yes, Judge, what he's
I know what
mentioning
you're
is-
saying, but
yeah,
I'm just asking
Yeah,
myself go to report to Hayville.
so what he's talking about, Judge, is that he does have a hold in Hateville.
Now, she told me,
So he will be sent to Hateville once his.
If he is detained at Hapeville, he needs to make sure Fulton County Probation knows that he's been detained, and that would delay his reporting time. And his probation for these 2 cases will be suspended until he reports. In other words, his 136 days won't start until he reports to probation.
14 days after I get out of Hayville, right?
Whenever you get out of Hapeville, sir, your first date is going to be with Fulton County Probation. Unless, of course, you would just like to finish the 130 days jail at the Fulton County and be done with it.
No,
Well, I don't know. A lot of people say no to that, but really you get it over and done with, but that's up to you.
I report.
Okay, thank you.
So
Thank you,
anyway,
Judge.
she gonna come with Hayville.
No.
Miss Vitaletti, are you the only PD right now?
Mr. McLean is here. Your
All right.
Honor.
Would you be able to speak to your client at ACDC because they need to go?
I can't, yes, Judge.
I can give you a phone number.
Okay. Do you want to just put it in the chat? So everybody's not, I mean, not that tons of people watch this, but I don't know if you want everyone calling it.
Miss Vigilante, I'm sure you have a fan base, so I'm sure a lot of people are watching this.
We're
So.
going viral, I'm sure.
There you go. On my
Thank
bed.
you, Sergeant. I appreciate it. Thank you. All right. Courtroom 2, where would you like me to address? I have jail court, iPhone, and medical as well. Good morning, Mr. McLean.
Good morning, Your Honor. I must have lost some weight. I was walking back and forth, but
Well,
I
in
probably
that case,
turned sideways.
congratulations. Congratulations. All right.
Can we go
yes.
to jail court's iPhone?
All right, we'll do that.
We have,
Good morning.
I'm
Who do
sorry.
we have, please?
good morning. We have a position number 12.
Okay. I'm crossing fingers and toes. That's Mr. McLean's case.
Who's number 12?
That is Oliver Morez. That's going to be Miss Vigilante's client.
We could do is Kenneth back here? No. Okay.
Let me see. Miss Vigilante, could we address jail court iPhone briefly, please?
I'm sorry, Judge, I'm not sure who this is.
This is Miss Position 12, Morez Oliver.
It's my understanding that the DA has requested a transfer on this case, so I've not spoken with Mr. Oliver yet.
All right. Miss Falk, could you please give me an announcement?
Yes, Your Honor. The state did ask the DA's office to look into this case because the charges were dismissed at magistrate court for child molestation and were sent down to us. Oh, sorry.
For a second,
So
okay.
we are asking them to look at it. I followed up with Miss McCauley yesterday from the DA's office, and I will follow up. She said she would look at it yesterday, so I'll follow up with her today and see if I can get a response on whether they're taking the case back.
So at the present time, there's no plea offer.
That is correct.
Okay. Miss Vigilante, with regards to this case, I'm going to reset it to May 30th. At that time, depending on the status of the case, the state will either provide you with an offer or you can have the case arraigned at that time.
Okay, Mr. Oliver, I will see you in advance of May 30th, okay?
All right. This is reset to May 30th. All right. Jail court, may I go to medical courtroom too, or should I?
Go to medical, Your Honor.
Position number 17, Patterson.
Thank you. Miss Vigilante, please call ACDC. I know they have another calendar that they're waiting on.
Yes, right now, Judge, thank you.
Okay. At the medical unit on Zoom, we have Mr. Shaka Patterson, case number 23 CR 585C. Mr. Patterson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning, that's going to be Mr. Michael McLean. Oh, no, it's a private attorney, excuse me.
Private attorney.
Mr. Brown Jr. Do we have counsel for Mr. Shaka Patterson on Zoom? All right, Mr. Patterson, it appears that you are represented by private counsel. Have you spoken to your attorney?
No, ma'am.
All right. Ms. Strong, do we have any updates from counsel, Mr. Brown Jr.?
No, ma'am, but I'll reach out.
All right. Mr. Patterson, I'm going to reset your case to May 28th at 9 a.m. And hopefully your attorney will reach out to you and we will address the case at that time. Presently, the state does have an offer, but like I said, your attorney would need to speak with you with regards to the offer. And so we will address it on May 28th at 9 a.m. Thank
Judge,
you.
he would like to know what is the charge because he didn't know anything about this case.
All right. This is Shaka Patterson. Charge is simple battery, family violence from December 12th, 2022.
Okay.
Thank you.
Thank you. All right, Mr. McLean,
We have Mr. Ellington, number 3, Your Honor.
at the courtroom 2, we have Mr. Gary Ellington, 19 CR 004-351A. Mr. Ellington, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. In this particular case, you were accused of 4 misdemeanor offenses stemming from a traffic matter: driving under the influence of alcohol per se, driving while license suspended or revoked, acquiring a license plate for purposes of concealment of the motor vehicle, and possession of an open alcohol container. I understand that this is going to be a negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. State's recommendation is going to be count 1, 12 months probation, served 22 days, credit for time served 11 days. That's going to be from May 13th, 2024 to today. Balance probated, ADET, DUI risk reduction, $1,000 fine, 240 hours of community service, 2 victim impact panels, and 2 AA meetings per month. Count 2, the driving while license suspended, is 12 months concurrent with count 1 and a $500 fine. Count 3 is 12 months concurrent with count 1. Count 4, the possession of alcohol container, is 12 months concurrent with count 1 and a $265 fine. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Sorry.
No, you're fine.
For that purposes, we do so stipulate. Thank you.
Mr. Ellington, have you consumed any alcohol or medication recently?
No.
And have you understood the proceedings so far?
Yeah.
I'm sorry, could you repeat your response?
Yes.
Are you satisfied with your legal services?
Yeah.
And has anybody forced you, induced you to take this offer today?
No.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to go back to court with your attorney, to confront your accuser, challenge the evidence brought against you, to be able to present any defenses, arguments, or mitigating factors if you choose to do so, and also have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering this plea freely, willingly, and knowingly?
Yes.
You understand you will be on probation, not only to pay a fine, but to complete various programs. Failure to complete the conditions as well, failure to pay your fine can result in a revocation of your probation and jail time for the remainder of the time of the sentence.
Yes.
You also understand that pleading guilty to DUI is going to suspend your driver's license.
Yes.
So you're not allowed to drive for the time that you're on probation until your license is reinstated.
Yes.
I'm also going to require you to abstain from all alcohol and beverages as well as illegal drugs. And you will be subject to random screens by probation. Are you willing to move forward with that, with the requirement of this condition?
Yes.
Okay, so you don't know if you can have a response.
How do you plead to 1 count of driving under the influence of alcohol per se, driving while license suspended or revoked, acquiring a license plate for purposes of concealing the motor vehicle, and possession of an open alcohol container from February 17th, 2018?
Yes.
Your sentence on the DUI is 12 months to serve 22 days, credit for time served 11 days. Mr. McLean, does your client have any other holds presently?
I was unable to use my laptop yesterday, Your Honor, to check the holds. And my desktop was frozen, so I would have to ask the clerk to check if there are any holds. And that was my fault. Well,
No, that's okay.
I don't know about the desktop freezing, it's not my fault. But it's ornery, but I'm getting it to work sometime.
All right, no problem. Just give me a
Your
moment.
Honor, this appears to be the only thing holding him in custody.
Very
Okay,
good, very
in
good.
that case, then Mr. Ellington, your jail time for this case is completed. You will be released within 24 hours and you must report to probation on Tuesday, May 28th, before 3 p.m. The
Your Honor,
probation, yes, sir?
I don't mean to interject just yet, but I do ask one thing when Your Honor is through with this part.
All right, so let me just continue. His probation report date is next Tuesday before 3 p.m. and the location is 132 Mitchell Street in downtown Atlanta. While he's on probation, he will complete the following conditions: an alcohol and drug evaluation and submit himself to any treatment as required, and that must be done within 30 days from today. He must enroll in a DUI risk reduction program within 30 days from today. He needs to pay a $1,000 fine. He needs to complete 240 hours of voluntary community service. He needs to complete 2 victim impact panels, and that must be completed within 90 days from today. And he needs to attend a minimum of 2 AA meetings per month. And he must show proof of attendance to his probation officer. With regards to driving while license suspended or revoked is 12 months concurrent to count 1 and an additional $500 fine. Count 3 is 12 months probation concurrent to count 1. Count 4 is 12 months concurrent to count 1 with an additional $265 fine. His total fines are $1,765. He must make a minimum payment of $50 per month, every month, and then pay off the balance by the end of the term of his probation. All fines must be paid. He needs to complete his 240 hours of community service with a minimum requirement of 20 hours of community service per month from the time he begins probation. And I believe that concludes the sentence. Oh, and he has to abstain from all alcoholic beverages and illegal drugs. He will be subject to random screens by probation. Any questions, Mr. McLean?
Yes, Your Honor. And this is really a question for the state because of the year that it occurred in. And of course, we had a good discussion of all the things that he could remember on the factual basis for the stop and the procedures on the roadside. But I wondered if the state could tell us for sure what it's listed as per se. What was the percentage that was alleged to have been blown? You're on mute. You're on mute, Ms. Hall.
I said, yes, just give me a moment. I was on the in the middle of doing a transfer order and I don't want to lose that on my Odyssey screen. So I'm going to have to open up another Odyssey screen real quick.
Understood. Thank you for indulging us on it.
Not a problem. And Your Honor, while we're doing that, I did get a response on Martez Oliver. They have asked that we send that case back. It is position 12. And so that was the order that I was preparing, was to go ahead and send that case back to the DA's office.
Okay.
Okay, for Mr. Ellington, you just pull up his paperwork and I can answer that question.
Right. Just wanted to make sure it was a point something. Because it's from 2018. He couldn't remember, and I said, it's worth knowing the details.
Okay.
And thank you, Your Honor, for the time spent on this.
Oh, I'm just wondering whether the deputy is looking at you right now. Okay.
Oh, no, they're busy doing something else.
All right. Okay. Deputy in courtroom 2, I think, was it? Oh, jail court iPhone. Deputy, we just addressed Mr. Morez Oliver.
Yes,
Sent back already?
yes, I know. I sent him back.
Okay, well, the prosecutor has just informed me that they are transferring the case to the DA's office. I'm still going to keep the May 30th date pending the transfer.
Okay, I'll deliver that message to him.
Thank you, appreciate it.
Okay.
I'm sorry, I'm unable to open the documents for this case, so I'm counting on the state.
And same, Your Honor, I'm not able to open mine either. So I'm not, I can see if I can have one of my, because of the case, the age of the case, it may be my permissions. Let me see if I can have someone else from my team open it up and see what the information is.
All right. Mr. McLean, we'll
So
get.
if you want to hold on
Fine.
this, we can.
All right, is this holding up the plea, Mr. McLean? Is there a request to withdraw the plea?
No, Your Honor, it is not, and there is not.
Okay, so that concludes his sentence for his case, and we will, if he can return to the gallery, but I can't hold up the calendar for this information.
I'll bring him that information. Thank
All
you.
right, thank you.
Okay, bye.
Who are we addressing next?
You can go to medical, Your Honor.
All right, and
Wow.
medical, who do we have?
Ricky Williams, this is position number 34.
All right, thank you, sir. All right, we are addressing the gentleman at the medical unit on the Zoom session. Ms. State versus Ricky Williams, case 24 CR 2909B. Mr. Williams, you have been cited with 5 misdemeanor offenses. Please remember that you have a right to remain silent. Anything you say in a court, your statements can and will be used against you. You have a right to an attorney, and representing you will be Mr. Michael McLean. The charges against you are battery at a public transit vehicle or station, violation of certain acts at a bus rail station, 2 counts of criminal trespass, and a second count of battery at a public transit vehicle or station. This stems from a May 6, 2024 incident. And Mr. McLean, how are we proceeding with regards to Mr. Williams?
Non-negotiated plea, Your Honor.
All right. Mr. Williams, we are going to have a non-negotiated plea hearing, which means that the prosecutor is going to give me their plea recommendation as well as your criminal history record and the factual basis for their recommendation. Your attorney will then give me his recommendation. I will let you know which option I'm going to choose, keeping in mind that I also have the option to disregard either plea and direct that this case be sent for trial. Ms. Mokaki, good morning.
Good morning, Your Honor.
Yes, and what's the recommendation for Mr. Williams?
The recommendation for count 1 is 12 months probation, serve 120 days, credit for time served 16 days, and that is from May 8th, 2024 to present. Balance probated, no further contact with Brandy Williams and Natalia Ramirez. Stay away from all MARTA stations, 8 weeks anger management, 60 hours community service. For count 2, that is probation concurrent with count 1. For count 3, that is 12 months probation consecutive to count 1. Stay away from all MARTA locations, excuse me. For count 4, we are going to merge that with count 3. And for count 5, that is 12 months probation concurrent with count 1. So this incident did take place on May 6, 2024. There were 2 incidents that actually took place on this date. The first victim was Brandy Williams, and she contacted police and stated that she had been punched in the face by the defendant. About 10 hours later, a second victim, Ms. Natalia Ramirez, contacted police and said that she had been struck by the defendant several times. CCTV footage confirmed both incidents. Mr. Williams, the defendant, has a lifetime ban from MARTA, and that came into effect on October 20th, 2021. He has multiple trespass arrests as well as a trespass conviction from 2023. Let's see. He does have that lifetime ban from October 20th, 2021, but he had a criminal trespass from MARTA February 18th, 2024, another criminal trespass, June 5th, 2023, another criminal trespass, April 17th, 2023, another one, January 28th, 2023. He has a simple battery from October 22nd, 2022 from MARTA because he punched a woman in the face. Another criminal trespass, October 23rd, 2022. I could keep going, but I think there's a clear pattern here where he either does not understand that he has a lifetime ban from MARTA, or he's simply choosing to disobey that lifetime ban. He has had instances of inappropriate behavior on MARTA. He's been violent in the past. That violence has only escalated to now he's assaulting 2 people on the same day. And that is why the state's recommendation is what it is. And I would like to sound for the victims, Ms. Brandy Williams and Ms. Natalia Ramirez, and then also ask that the defense stipulate as to venue, factual basis, and identification for purposes of the plea.
And Your Honor, because he is not in the courtroom, it would be appropriate for me to ask if we could go to something else while we look at the opportunity of doing a breakout room so I can speak to him briefly. I do have my phone with me, but it won't connect in the courtroom because of the signal. But if I go over to the next room and stand by the window, I'll be able to zoom in and do a breakout room. I just need to speak to Ricky Williams briefly.
Okay. Go ahead, Mr. McLean, and let me just find out one thing. Jail court iPhone, who do we have?
I'm sorry, Your Honor. We have position number 18, Mr. Victor Payton.
Position number 18 is represented by Mr. McLean. Mr. McLean, is that going to be a probable plea?
Yes, Your Honor, it is. I do need to speak to him briefly, but it's a problem.
You need to speak to both of them?
Right. If we could do the same at the same time, I mean sequentially, not literally at the same time, but I'll have the iPhone at the window.
Okay, go ahead and get connected to Zoom so you can get a chance to speak to Mr. Patterson as well as to Jail Court iPhone. Jail Court iPhone, counsel wants to speak to his client there as well.
Okay.
All right. Ms. Vigiletti, are you ready to address the probation revocation matter for Tonya Brown?
Yes, Judge, I'm sorry, one second.
All right. Medical and Jail Court iPhone, please hold while Mr. McLean comes on the Zoom so that he can speak with you. Before I begin, we have an individual who is on a Zoom screen, and the only identification of the Zoom screen is a dot. I'm going to give you 5 seconds to start your video, otherwise we're removing you from Zoom. You have been asked several times by the host. Okay, all right, that's fine. Could you give us your initials, please? Just put it in the chat. That's all we need, just a chat. Just in the chat, put your initials. Thank you. All right, now that that's been identified, thank you. Ms. Vigiletti, we are returning back to the probation revocation case involving Tonya Brown. It appears that she has, well, what do you want to tell me?
Yes, Judge. So where we left off, we were discussing, Ms. Brown's severe injury, and Ms. Allen was explaining that that's why the hearing was scheduled. And I did talk to Ms. Brown. You can see from her history, she's not a person who's been in a lot of trouble. It looks like the hearing notice was sent to an old address. And just now when I talked to her about it, she said, no, it shouldn't be, because when I moved, I updated my address, on my license, and didn't realize that, of course, the jail and probation contact information is a totally separate issue. She was thinking, hey, I updated my address with the state. It should be updated everywhere. So she didn't get notice of a hearing, didn't realize a hearing was necessary. And it was just a mistake, missing that court date, after submitting the information to her probation officer. She did also want to clarify that she did submit to Officer Charlo proof of 40 hours of community service in the first month of her getting out and being put on probation, but she does still have that proof, so she's happy to resubmit, once she is out.
Okay,
And Your Honor, she is correct. We did receive proof of community service, but also we not only sent the notice to appear to her address listed, we also sent it to her email address as well.
all right, thank you. Ms. Tonya Brown, I appreciate that you had an injury, but that still doesn't discount the fact that you knew that you had an open probation case. You had the benefit of a reduction in your charges in which you were convicted of reckless driving instead of a DUI, which would have had a much more adverse impact upon your criminal history record. But the fact remains that even though you have plausible excuses as to why you didn't show up for your revocation hearing, you do not have plausible excuses for failure to comply with probation and complete the remainder conditions of your probation. I'm revoking your probation and requiring you to complete the rest of the time at the Fulton County Jail. Once you have completed the remainder of your time, then your probation is completed. Thank you.
Thank you, Judge.
Thank you. Judge May will be dismissed.
Yes, thank you, Sergeant. You have a good day. Thank you.
You too. You too.
All right, has the host placed Mr. McLean into a breakout already?
Yes, ma'am.
All right, thank you. Ms. Vigiletti, do we have a case where we can address
This is gonna be position number 20, Mr. Gray.
20? Thank you. Ms. Vigiletti, is this going to be a negotiated plea?
Yes, Your Honor.
Okay. This is Tamarius Ray, R-A-Y, case number 20 CR 2833B. Mr. Ray has been accused of misdemeanor possession of marijuana, 2 counts of simple battery, and 1 misdemeanor count of obstruction of a law enforcement officer from August 5th, 2018. Mr. Ray, you've been advised of your right to remain silent, and your attorney is going to be Ms. Vigiletti. For purposes of this plea hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Mukak?
Yes, Your Honor. For count 1, the state will be no crossing that charge.
Mhm.
For count 2, it will be 12 months probation, served 20 days, credit for time served 10 days, and that is from May 14th, 2024 to present. Balance probated, and that will be concurrent with count 3. Count 3 is 12 months probation, served 20 days, credit for time served 10 days, balance probated. For count 4, that will be 12 months probation, 40 hours community service, and a $300 fine.
Right. Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea, Your Honor.
Mr. Ray, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And has anybody forced you or induced you to take this plea offer today?
No, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get a chance to go back to court with your counsel to present your defenses and arguments, to challenge the evidence brought against you, to confront your accuser, and have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to 2 counts of simple battery and 1 count of obstruction of an officer?
Yes, Your Honor.
On the marijuana charge is dismissed. Count 2, simple battery, is 12 months to serve 20 days, credit for time served 10 days. You will report to, does he have any other holds, Ms. Vigiletti?
No, Your Honor.
All right. In that case, he will report to probation to serve out the rest of the time. His probation report date is May 28th before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While he's on probation, he will also complete the conditions for count 3, which is also concurrent to, well, it's also 12 months probation, credit for time served 10 days. With regards to the obstruction of a law enforcement officer, is 12 months probation, where he will need to complete 40 hours of voluntary community service. He must begin with a minimum of 5 hours per month with any nonprofit agency that's not a church and not a school. He will also need to pay a $300 fine with a minimum payment of $20 per month. And to pay off the fine, any objection to non-reporting upon completion of conditions, Ms. Mukasey?
No, Your Honor.
All right. Once he has completed all his conditions, including the 40 hours of community service, paying off the fine, then his probation may be non-reporting.
Thank you, Judge.
All right. Thank you.
Next is gonna be position 24 and 25, Mr. Brandon Spear.
This is Brandon Spear. Case is 22 CR 8525H, accused of willful obstruction of an officer, misdemeanor possession of marijuana, and misdemeanor possession of a drug-related object. Position 25, Mr. Brandon Spear is got a bench warrant, 24 FTA 582. Mr. Spear, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. So we are going to have a plea hearing. Mr. Spear, please raise your right hand. I'm sorry, Ms. Vigiletti, did you have something to add?
I'm sorry, Your Honor. Could I please speak with Mr. Spear for a moment? He had asked me for some information that I want to give him before we move forward.
All right, we'll go ahead.
Thank you.
With the host, please let Mr. McLean know that he would need to move on to his second breakout with medical.
Yes, ma'am.
Thank you. All right, Mr. McLean, are you ready to go into your breakout with medical? I think that was a yes. So
Yes, Your Honor.
great. All right, I think you can go back into the same breakout room. I don't know. I'm going to let Miss Strong. Medical, please take a note of the message on the screen to join a breakout session with Mr. McLean. Deputy at Medical, you'll see a message on your screen to join a breakout, please. Thank you. All right. Okay, Ms. Vigiletti?
Yes, Judge, we're ready to move forward.
Okay. For purposes of the plea, Mr. Spear, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Repeat.
Yes, ma'am.
Thank you. All right, Ms. Mukasey, what's the recommendation?
Yes, Your Honor. The state's recommendation for count one is 12 months probation, serve 144 days, credit for time served 72 days, and that is from December 26, 2022 to February 24th, 2023, and then May 13th, 2024 to present. Balance probated, 40 hours community service, and a $300 fine. For count two, we are going to be no crossing that charge. For count three, time served 144 days, credit for time served 72 days, and that is concurrent with count one. For purposes of the plea, I would ask the defense to stipulate to venue, factual basis, and identification. And then for the failure to appear, we will be no crossing that upon the plea.
All right. Ms. Vigiletti, what's the response with regards to the stipulation?
Yes, Judge, so stipulated. I did want to ask Your Honor if you would consider a non-reporting status upon completion of these terms.
Yes. Ms. Mukeke, any objection?
No objection from the state.
All right. Mr. Spear, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
You need to speak up a little because we are recording these proceedings.
Yes, ma'am.
Thank you. If you decide to enter this guilty plea to these charges, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of willful obstruction of a law enforcement officer and one count of possession and use of a drug-related object?
Guilty.
On count one, your sentence is going to be 12 months to serve 144 days, credit for time served 72 days, balance probated. You will report to probation on Tuesday, May 28th before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must begin with a minimum of 5 hours per month and 5 hours every month thereafter. You will also pay a $300 fine, and you will need to pay a minimum of $30 per month until the entire fine is paid off. On count two, the sentence will be to serve 12 months to serve 144 days, credit for time served 72 days, concurrent with count one. Once you have completed your community service, you have paid off your fine, and you're up to date with your probation fees, then your probation will be non-reporting. Thank you.
Thank you, Judge.
All right, Mr. McLean, are we ready to address your client who's at the medical unit? And if you can refresh my memory, what's that? Mr. McLean?
Your Honor, I am ready to go forward with Ricky Williams and finish that plea up, and
Okay.
then I need to touch base with. I'm trying to, these things take a few minutes because I'm using one finger here at the window. But I'm logging in to check on something on the computer, and then I'll need to go back very, very briefly with Mr. Payton.
All right. Ricky Williams?
We can finish up Ricky Williams right now. Your
All
Honor,
right.
we're changing over from non-negotiated to negotiated plea on that.
Okay. So, Mr. Ricky Williams in case 24 CR 2909B, position 34 on our calendar. Mr. Williams, you've already been advised of your charges. The prosecutors already indicated their recommendation, and your attorney has indicated that they are in agreement, that you are in agreement with the recommendation offered by the prosecution. So, Mr. McLean, do you stipulate to the factual basis, venue, and ID for purposes of the plea?
For said purposes, we do so stipulate. We have calculated for him that 44 extra days included as part of this plea. So, yes, Your Honor.
It would be 120 days less 16 days here. So he would have 44 days left at the jail, after which he'll be on probation.
So how many days I gotta do now? 44 more days?
4-4.
All right.
And then you will be on probation.
Probation?
Yes, sir.
That's cool.
And then you
8.
need to stay away from all model property, at least 200 yards away. You're not allowed at a bus station or a train station.
That's cool.
Good. Mr. McLean, shall I
Ways
proceed?
seen is death, the gift of God is eternal life.
So let me speak over
I'm
you.
so sorry, Mr. McLean. What was that, Mr. Williams?
I was gonna just
Let them know that. You ain't gotta tell them.
well, I was gonna remind you of the 60 hours of community service and the 8 anger management classes while you're on probation. That's a requirement. Very serious.
All right, please unmute medical. Okay. Mr. Williams, have you consumed any medicine or alcohol recently?
I took my meds this morning.
All right. Are you still able to
Look back.
understand? Are you still able to understand your attorney and what's going on in your case so far?
Huh?
Are you able to understand your attorney and what's going on in your case so far?
No.
Okay. So
No.
we're going to reset the case to next Thursday. And hopefully he'll, after taking his medication, he's in a more lucid state to understand what's going on in his case. Thank you.
Very, thank you.
Mr. McLean, you said you're not ready to address your client at the jail court iPhone, or you are ready?
I'm not. I need to go back to him, Your Honor, because at the same time, simultaneously, I'm logging into the email. So that's going to take about maybe 3 or 4 or 5 minutes.
So are you ready to go into a breakout now, or?
Yes, I am,
Okay.
Your Honor.
Ms. Strong, if you could place Mr. McLean back in his breakout room. Jail court iPhone, you would need to return to the breakout room. Ms. Vigiletti in courtroom 2, are we ready to address any of your other clients?
Ms. Vigiletti's talking to one of her clients right now, Your Honor.
Okay. Deputy in courtroom 2, is that Officer Norris?
Yes, Judge Law.
All right. Good morning, sir.
How you doing?
I'm doing good, thank you. Do we have any more probation revocation cases in courtroom 2 that would soon be addressed?
They're all gonna be with jail court's iPhone.
I see. Okay. All right. We have Rainwater, just Rainwater left, just one other. Dalen Rainwater, that's the only one.
Yeah, he's gonna be with jail court iPhone.
Okay. All right, I guess we are in a brief recess until Miss Vigiletti is ready to proceed. Please let her know that we are waiting on her.
Okay.
Thank you. All right, Deputy Norris, I'm ready to address Ms. Vigiletti. Ms. Vigiletti, may we get to your case, please?
She's still talking to her clients, Your Honor.
I need to move on, otherwise we're never going to get through this morning. We can take a reset for her case if that's required. Medical, who do we have?
Now, Mr. Butler is position number 2.
All right. Please hold. Mr. McLean is in a breakout with one other client, and then we'll take up Mr. Butler.
And Your Honor, I got 2 clients of Mike McLean's in the.
Yep, I'm going to close out. Ms. Vigiletti, how are we proceeding on the next case?
Yes, Judge, I'm ready with positions 7 through 9, Mr. Terry Jules.
Okay,
Mr. Jules would like to enter a plea of not guilty this morning. I'm happy to file a waiver of his arraignment.
all right. Mr. Terry Jules has got 3 separate cases, 24 CR 2976G, disorderly conduct and violations of the pedestrian rules. Position 8 is 24 CR 2977G, failure to obey a traffic control device. And position 9, again, violation of pedestrian rules from September 25th, 2023. Looks like he's got another case, 24 CR 1899G as well. Did I miss that one?
Yes,
Looks like
Ms.
he's
Fox
got-
added that on to her recommendation.
Okay, so but he's got 4 open cases then with State Court of Fulton County.
Yes, Your Honor.
Okay, so and are you filing a waiver arraignment with regards to all 4 cases?
Yes, Judge.
All right, so please make a note, there's 4 separate arraignments, waiving arraignments. And Mr. Jules, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Your attorney has filed a not guilty plea on your behalf, and your cases will be further noticed for trial. Thank you.
Thank you, Your Honor.
Excuse me, Judge, can I get the case number for that 4th case?
24 CR 001899G.
Thank you.
Okay. Mr. McLean, have the individual whom you're addressing at Jail Court iPhone, could you refresh my memory? Which case is that? Mr. McLean, please unmute. Oh, can't hear you.
There we go.
Uh,
Yes, Your Honor. Victor, which is number, first name Victor.
Position 18?
18, okay.
Eight-
All right, sir.
18. That's a negotiated plea, Your Honor.
All right. And this was State versus Victor Payton, 23 CR 5427G. Mr. Payton was accused of theft by shoplifting from December 7th, 2021. Mr. Payton, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean is your counsel. Mr. Payton, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on this is 12 months serve, 160 days, credit for time served, 80 days. That's from March 5th, 2024 to today. Balance probated, $500 fine, anti-theft course, stay away from the Rainbow Clothing Store at 20A Broad Street Southwest, and 40 hours of community service. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That is all for the state.
Thank you. Mr. McLean, do you so stipulate?
We do so stipulate for those purposes, Your Honor. Apparently, this happened back on 12/7/21. He does remember the incident, and he wishes to ask the court to accept his plea.
All right. Mr. Payton, have you consumed any medicine or alcohol?
Oh, no.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
And is anyone forcing you to plead guilty today?
No.
If you decide to plead to this case, you would have to give up your right to a trial in front of a judge or a jury. You will not get a chance to be in a courtroom with your attorney, to confront your accuser, challenge the evidence brought against you, to be able to present your arguments and defenses if you choose to do so, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
And you understand that if you are, if you have 3 or more convictions for theft by shoplifting on your record, any subsequent arrest can be a felony charge.
Yes.
Are you still willing to move forward with this plea freely and knowingly?
Yes.
How do you plead to 1 count of theft by shoplifting?
Yes.
Your sentence is going to be 12 months to serve 160 days, credit for time served 80 days. If you have no other holds at the jail, you'll be released within 24 hours. You must report to your probation officer on Tuesday, May 28th, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete an anti-theft class, and that must be completed within 90 days of being released. You will pay a $500 fine, and you must make a minimum payment of $50 per month and $50 every month thereafter. You will also complete 40 hours of voluntary community service, and you must begin with a minimum of 5 hours per month and complete the 40 hours while you're on probation. You will report to probation every month, and you are to stay away from the Rainbow Clothing Store at 20A Broad Street in, which city is this in?
Atlanta is down right at 5 Points.
Okay, you need to stay away from that store. Thank you.
All right, thank you.
Mr. McLean.
Number 2, Butler, number 2.
All right, Mr. McLean, you have a client at the medical unit. Are you ready to proceed from your current location?
Yes, Your Honor. Number 2 is what person again?
This is Stuart Butler, accused of simple battery, and he is at the medical unit.
And we had, I put in the announcement yesterday of.
Negotiated plea?
That's correct. We're ready to go forward. I don't have the paperwork in my right hand, but I do recall it. So we're ready without moving into the other room.
Okay. Mr. Stuart Butler, can you hear me, sir?
Yes, ma'am.
All right. Your case number is 24 CR 2141Y, in which you are accused of simple battery from April 22nd of this year. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Can you see your attorney on the screen?
Yes, ma'am.
Okay. Mr. Butler, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on the 1 count of simple battery is 12 months, served 64 days, credit for time served 32 days from April 22nd, 2024 till today. Balance probated, stay away from 2890 Fulton Drive Northeast. That's the Atlanta International School. No further contact with Malik Suthar and Juvenile US. 12 weeks of anger management, 40 hours of community service, and no firearms. We would like to sound for Mr. Malik Suthar at this time, and we do ask that the defense stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Mr. McLean, do you so stipulate?
For those purposes, we do, Your Honor. And those are the elements he expected to hear, and he asked the court to accept his negotiated plea.
I don't see a Malik Suthar on Zoom. Mr. Butler, have you consumed any medicine or alcohol recently?
Consume, medication.
All right.
Like Risperdal.
Oh, you don't need to tell me what it is. I just wanted to be sure that after consuming the medicine, are you still able to understand what's going on in your case?
Yes, ma'am.
Are you able to understand your conversations with your lawyer?
Yes, ma'am.
And are you satisfied with the legal services?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
And has it been explained to you that if you enter such a plea, you would have to give up your right to a trial in front of a judge or a jury? You will not
Yes,
get a
ma'am.
chance, you will not get a chance to come back to court with your lawyer to confront your accuser, to challenge the evidence that could be brought against you, to present your own defenses, arguments, and mitigating factors if you choose to do so, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery?
Guilty.
Your sentence is 12 months to serve 64 days, credit for time served 32 days. The balance will be probated. You'll report to probation next Tuesday, May 28th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you are to stay away from the Atlanta International School at 2890 North Fulton Drive in Northeast Atlanta. You're to have no contact with Malik Suthar and the minor identified as US. While on probation, you will also complete 12 weeks of anger management classes. You must enroll in those classes within 30 days from today. You're also to complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will begin with a minimum of 5 hours of community service per month, beginning with 5 hours in the first 30 days. At all times while you're on probation, you will report every month, and you're not allowed to possess any firearms. You are to relinquish possession of any and all firearms that you own, and you cannot have any in your home, on your person, and in any vehicle that you possess or occupy. Thank you.
All right.
Thank you, Your Honor.
All right. We are moving on to Mr. McLean. Is it a quick journey back to courtroom 2?
It's a pretty quick journey. I'll run back there, Your Honor.
Thank you.
Thank you.
All right. Jail court iPhone, who do we have, please?
We have positions 13 through 16, Mr. Pack.
Please hold for just a few seconds, and his attorney, Mr. Michael McLean, will appear on courtroom 2.
Okay.
All right, 13 through 16. Okay. We are addressing positions 13 through 16, State versus Kenneth Pack. On position 13, Mr. Pack's case is 23 CR 6577C, accused of criminal trespass from October 21st, 2023. In which his second case, position 14, is 23 CR 6878C, in which he's accused of criminal trespass and simple battery against a police officer from November 3rd, 2023. Position 15 is Mr. Pack's third case, 24 CR 40C, in which he's accused of criminal trespass and violation of certain rules and acts at a bus or rail station from January 2nd, 2024. His fourth case is 24 CR 2251C. Mr. Pack is accused of criminal trespass, willful obstruction of an officer, certain acts of at a bus or rail station which are prohibited, and PI, which is a misdemeanor offense from April 24th, 2024. Mr. Pack, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. Representing you is Mr. Michael McLean. We are going to have a non-negotiated plea hearing with respect to all 4 cases currently pending against you.
Your Honor, we're changing that today. I discussed it with the state prior to court session, and we're changing that to a negotiated plea.
Okay. We are having a negotiated plea hearing with regards to all 4 cases against you. So may I place you under oath? Mr. Pack, if you'll raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you.
Yes.
You lower your hand. Ms. Cole?
Yes, Your Honor. Starting with Mr. Pack's first case, the state's recommendation is that case is 12 months served, 8 days, credit for time served, 4 days. That is from October 21st, 2024 to October 23rd, 2024, balance suspended, ban from MARTA in compliance with his already existing lifetime ban. Position 14, count 1, 12 months concurrent with count 2. Count 2, 12 months served 60 days, credit for time served 5 days from 11/3 to 11, I believe that was changed to 11/8, 2023, balance probated, stay away from all MARTA, 12 weeks anger management. Position 15, criminal trespass, 12 months served 6 days, credit for time served 3 days from January 2nd to January 4th, balance suspended on that one, my apologies. Stay away from all MARTA, count 2, 12 months concurrent with count 1. Position 16, the criminal trespass, 12 months probation, serve 30 days, credit for time served 29 days. That's from April 24th of 2024. Balance probated, stay away from all MARTA. Count 2, 12 months concurrent with count 1, $300 fine. Count 3, 12 months probation concurrent to count 1. Count 4, 12 months probation concurrent to count 1. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Excuse me, Judge. And
Yes,
Ms. Falk, before you start, Judge, with position number 16, Ms. Falk, there's no conditions. Is that going to be balance suspended as well?
There are conditions. If you look at count 2, there is a $300 fine.
Okay, thank you.
So that's why that's going to be balance probated.
Okay, thank you.
Thank you.
Thank you.
Well, he's got to be on probation for position 14 as well. And I understand that he's got to have additional jail time.
That is correct, Your Honor.
Okay.
Oh. What's that?
So there'll be 25 days additional jail time.
Correct.
Okay. All right, Mr. McLean, does your client stipulate to the factual basis, venue, and ID for all 4 cases?
For all 4, yes, Your Honor, we do.
All right. Mr. Pack, have you consumed any medicine or alcohol recently?
Yes.
All right. And did you consume medication?
Yes.
After consuming the medicine, were you able to understand your attorney?
Yes.
And do you understand what's going on in all 4 cases against you?
Not entirely.
Do you need to speak with your attorney to understand?
Yes.
All right. Mr. McLean, as your client has 25 additional days to serve at the jail, would you like to address the case today, or would you like to address the case next week?
I would like to try to address it today. If I could do another breakout, that'll necessitate me going over to the window in the other room, but I think we'll be able to get through it today, hopefully. Got my fingers crossed.
Okay. Jail Court iPhone, do you have another case we can address? Mr. Pack needs to speak to his attorney since he doesn't understand certain things.
Your Honor, can we move on in courtroom 2?
Yes.
The rest of these are Mike McLean's clients. Okay.
All right. Jail Court iPhone, please hold, and Mr. McLean will need to speak to his client. Who do we have in courtroom 2?
This is going to be position 32 and 33. Mr. Williams.
I believe.
This is Barnigo Williams, is that correct?
Okay, yeah.
Okay.
Yes, Your Honor, that is. That is a negotiated plea this morning, Your Honor.
All right. We are addressing courtroom 2, Mr. Barnigo Williams. In position 32, case is 21 CR 7020Y. Mr. Barnigo Williams is accused of driving under the influence of alcohol less safe, reckless driving, failure to maintain lane, and misdemeanor obstruction of an officer from August 29th, 2020. He's got a second case, and that's a bench warrant 24 FTA 586 from December 20th, 22. Mr. Barnigo, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Ms. Mukaki, what is the recommendation for Mr. Williams? Barnigo.
Yes. The recommendation for count 1 is 12 months probation, serve 60 days, credit for time served 24 days. And that is from August 29th, 2020 to, that is just for August 29th, 2020, and then May 1st, 2024 to present. That's going to be balance probated, DUI risk reduction, 2 victim impact panels, AA 2 times a month, 240 hours community service, an ADET, and a $2,500 fine. For count 2, that is going to merge with count 1. For count 3, that is 12 months probation concurrent with count 1 and a $265 fine. For count 4, that is 12 months probation consecutive to count 1 and a $300 fine. The state will be null processing the FTA. And I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
So we're subject to 24 months probation, less 60 days, to pay a 2,800, so it'll be a fines of in excess of $3,000, and to complete the 240 hours community service in addition to the other programs.
Yes, Your Honor.
Okay. Mr. McLean, I'm not certain, but just based on body language observations, I don't think Mr. Barnigo Williams was contemplating this offer.
Not the, apparently I missed the consecutive nature of one of the counts in our discussion yesterday. Therefore, I need to explain to him and discuss with him that it would be 24 potential probation months, unless shortened by his performance, rather than 12. I know that sometimes even in a situation like this, he may not have to experience a full reporting on all 24 if he does rather well in the first several months and gets his requirements and obligations out of the way. But I think that's what I need to discuss with him.
All right. Just to see if the state would object, he would need to be on active for probation for the first 12 months, less 60 days. And if he completes all the conditions, the fines, the probation, he's up to date with his probation fees, and he's completed all the conditions for the DUI, then his probation will be non-reporting for the consecutive term. So please mute your screen if you want to have a quick chat with him.
Okay, let's mute.
It's not muted, Mr. McLean? Okay, now it is. Thank you. All right, Mr. McLean, are we ready to proceed, or would you like a reset to go over the terms again?
No, Your Honor, he does understand. My apologies. I discussed with him that it would be 10 active months of probation and go to non-reporting if he's performed. And the
But
calculation,
only upon compliance of all the conditions. That's the only trigger for non-reporting.
correct. He understands that this is an extra time plea that will require him to be here till this coming 6 days from now.
All right. Ms. Mokaki, just for the court's context of this sentence, proposed sentence, how many DUI convictions does Mr. Williams have on his record?
I see a 2024 DUI, a 2014 DUI conviction, a 2016 DUI conviction, and then for arrest, I see a 2023 DUI arrest, 2018 DUI arrest, 2020 DUI arrest, time expired, another 2020 DUI arrest, and then another 2020 DUI arrest.
Thank you. Mr. McLean, you're based on this significant record with regards to your client, his license will be suspended for up to 24 months.
Yes, Your Honor, I'll tell him to.
He's not eligible for reinstatement for up to 24 months.
Understood, Your Honor.
All right. Do you stipulate to the factual basis, venue, and ID?
For the purposes of the plea, we do so stipulate.
All right. And Mr. Williams, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
You need to speak up, sir. We need to have your responses recorded.
Yes, Your
Have
Honor.
you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you to take this plea offer today?
No, ma'am.
If you decide to enter this plea, you would have to do so freely, willingly, and knowingly. Has that been explained to you?
Yes, ma'am.
In that light, has it been explained that if you decide to enter a guilty plea, this will be an additional DUI conviction on your driving history?
Yes, ma'am.
This can impact your other open cases. This can impact your residency if applicable. This can impact your job. Has that been explained to you?
Yes, ma'am.
Are you still willing to move forward?
Yes, ma'am.
By pleading guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the assistance of counsel to go back to court, to confront your accuser, challenge the evidence that will be brought against you, to have the assistance of counsel to present your defense's arguments and mitigating factors if you choose to do so, and have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of driving under the influence of alcohol less safe from August 29, 2020, one count of reckless driving, one count of failure to maintain lane, and obstruction of a law enforcement officer?
Guilty.
On DUI charge, your sentence is going to be 12 months to serve 60 days, credit for time served 24 days. I believe you have 3 more days to serve at the Fulton County Jail. Would that be correct, Mr. McLean?
I believe it'll be 60 divided by 2 will be 30 minus 24 will be 6.
So he has 6 more days?
Correct.
Okay.
That'll be this coming Wednesday.
All right. So, Mr. Williams, once you are released from the jail, you will report to probation next Thursday, May 31st, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. If you are not released in time to make it to the May 31st report date, I will give you another report date, which is going to be June, the first Monday in June, and that's going to be June 3rd. Do you understand, sir?
Yes, ma'am.
And that's a Monday, and you either report, and let me just amend the date. You either report on May 30th after you're released from the jail or June 3rd. I'm going to give you the option of the 2 dates just because I don't know whether you'll be released in time for the Thursday date. When you report to probation, you will be on probation to complete certain requirements. And those requirements are to do a risk reduction class, and that must be done within 60 days of being released. You will attend and complete 2 victim impact panels, and that you will within the 10 months while you're on active probation for this first, for the count 1. You will attend AA twice a month. You will complete 240 hours of voluntary community service, which means you must do a minimum of 20 hours of community service in the first 30 days and a minimum of 20 hours every month thereafter. You will submit to an alcohol and drug evaluation within 30 days of being released. And you must submit to all treatment that's required for any substance or alcohol abuse. And that must be paid off from your own pocket. You will also be subject to a fine of $2,500. And this is a statutory fine based on your multiple DUI convictions in the past. Count 2 of reckless driving will merge with count 1. The failure to maintain lane will be 12 months probation concurrent with count 1 with an additional fine of $265. And the count 4, obstruction of a law enforcement officer, will be 12 months probation consecutive to count 1 with an additional $300 fine. While you're on probation, whether it is active probation or non-reporting, Mr. Williams, you are not to consume any alcohol and you're not to consume any illegal drugs. You will be subject to random screens by probation, whether you're on active or non-reporting probation. You can be called in anytime during the 24 months that you're on probation to be subject to a screen for alcohol and or illegal drugs. If you fail the screen, probation is authorized to revoke the remainder of the time and have you serve out that time in the Fulton County Jail or in prison, depending on the time that you've remained on probation. While you're on probation also, you are not authorized to drive. You will not be eligible for reinstatement of driver's license until you have completed all probation requirements, active and reporting and non-reporting for this particular case. Your probation, your first 10 months of probation will be active. After that, your consecutive term of probation may be non-reporting if you have completed all the conditions. All fines, including the fine for obstruction of law enforcement officer, are all paid off, including court costs and surcharges, and your probation fees are up to date. Thank you.
Your Honor, if I might mention one other thing, this is not to quibble with the elements of the sentence, but I told him that I told him that probation has certain standards about the classes, the RR, the VIP, and that sort of thing, and that if he has indeed recently enough, according to their standards, completed the same class, they may, in their discretion, say you've done an RR recently enough, that's good enough for us. So I didn't want to have the court, get involved in that level of detail, but I did want to advise that I advised them that they would have the discretion to do that if it was.
I absolutely defer to probation discretion in most cases, but under these extraordinary circumstances where Mr. Barnago Williams has not only got multiple DUI convictions on his arrest, but a shocking number of DUI arrests. I don't know how many open DUI cases he still has open. So I need to know what was the latest DUI risk reduction classes that he took and completed. What is the latest date that he has completed?
Do you recall the date of the latest RR? No, I want you to figure out if you know the date. Can you remember the date of the last RR class that you took? He cannot recall. It would have been within the last, probably within the last 14 months, Your Honor, but I can't.
The court will only accept a completed risk reduction program in 2024.
Understood.
Mr. Williams does not get the message that he cannot operate a vehicle while under the influence or after consuming any kind of alcohol or illegal substance. So given his history, Mr. Williams, with all due respect, I don't trust you to be on the roads. I believe that you are a significant danger, not only to yourself, but to other motorists. So I will only accept a risk reduction, a victim impact panel, completion of community service, an a completed alcohol and drug evaluation and all treatment required. If they were completed, they were started and completed in 2024.
Within the calendar year. I understand, Your Honor.
No, sir. No, sir. Not within the calendar year. If he started in the last, today is May 23rd, only in this year. We must have enrolled and completed those programs in 2024.
Right. That's calendar year 2024. We're on the same page.
All right, thank you. I didn't want you to think it was in the last 12 months.
No, that is not what I intended to apply.
All right, thank you. Thank you.
Good morning, Judge. Sorry for the interruption. How are you?
I'm doing great. Thank you, Ms. Jenks.
Quick question. I know I'm covering for Paul today for the competency calendar. Do you have an ETA on when that would start? I just wanted to know if I should have time to go from the courthouse back to the office or if I should just stay put here at the courthouse.
I'm going to shoot for 11:45.
Okay, great.
I know Ms. McLeod's also waiting.
Okay, awesome. Thank you.
Okay.
Appreciate
Thank you. Jail court iPhone, do we have cases ready?
Yeah, we have Mr. Pack, I guess, Mr. McLean had.
All right, Mr. McLean, I'm going to put you in a breakout. Courtroom 2 and jail court iPhone will go into a breakout, please.
Thank you, Your Honor. Let's see if
Mr. McLean, if you look at the screen or whoever is managing the Zoom in courtroom 2, you will be placed in a breakout with a jail court iPhone. We'll be in a 5-minute recess unless anyone has any announcements to make. All right, it is 11:16. We will resume at 11:20. Thank you.
Jail courts, do y'all see it? Because it says y'all are already in the breakout room.
Miss Strong, can you confirm that jail court iPhone is in the breakout room with the courtroom 2?
It says it, Judge. I just asked him. I'm just trying to wait to see if he sees the prompt.
No, I don't see it.
Okay, maybe move them to a different room and then.
I will.
Thank
One
you.
moment.
All right, please hold. Jail court iPhone. Please hold. All right, Miss Strong, are they still in the breakout? Miss Grace?
Yes, they are, Judge.
Okay. Courtroom 2, is Miss Vigilante available? Oh, okay. Oh, they're ready. All right. All right, Mr. McLean, does your client still want to proceed with the plea, or would he need more time to go over the details?
He believes he's ready, Your Honor.
Okay. Jail court iPhone, please unmute for Mr. Pack.
Right. Yes, sir.
All right, Mr. Kenneth Pack, again, my name is Judge Law, and you've already been sworn. You've already spoken also with your attorney, Mr. Michael McLean. I'm going to ask you again, sir. Have you consumed any medicine or alcohol?
No.
And have you understood the proceedings so far?
Yes.
Do you understand your attorney in your conversations with him?
Yes.
And do you understand what's going on in your cases?
Yes.
If you understand that you're pleading guilty to 1, 2, 3, 4 separate cases, do you realize that?
Yes.
And do you realize that all of them stem from issues at a MARTA station?
Yes.
And do you understand that if you decide to plead guilty to these charges, that you have to stay very far away from all MARTA property? You cannot return to any train or bus station.
Okay.
And this is for the rest of your life.
Okay.
I know you are okay with it, but I want to know, do you understand that? And that's what you plan to do?
Yes.
All right, remember this. Mr. Pack, if you decide to plead guilty to these charges, you will not get a trial in your case. You will not get the chance to go back to a courtroom. You will not have an attorney to help you. Do you understand that?
Yes.
And you will not get a chance to confront your accuser or challenge the witnesses and the documents that may be brought against you. Do you understand that?
Yes.
Do you understand that your attorney cannot help you then to present your defenses and your arguments before a judge or a jury? Are you prepared to give up that right?
Yes.
And are you prepared to give up the right to make the state do its job and prove the charges against you beyond a reasonable doubt? Are
Yes,
you
Your Honor.
prepared to give up that right?
Yes.
Okay, I just want to be sure.
I'm sorry.
On position 13, 23 CR 6577C to the charge of criminal trespass at MARTA on October 21st, 2023, how do you plead?
Guilty.
Your sentence is 12 months to serve 8 days, credit for time served 4 days, balance suspended. You are to comply with your lifetime ban and stay away from all MARTA bus stations and train stations. Do you understand, sir?
Yes, Your Honor.
Good. On position 14, how do you plead to 1 count of criminal trespass and simple battery against an officer from November 3rd, 2023?
Guilty.
I'm not going to do this hearing if you don't let me finish.
I'm sorry.
The reason I want to make sure that I finish my sentence is because I don't want you to ever say you didn't understand the judge. Are you listening?
Yes.
As I was saying, how do you plead to criminal trespass and simple battery against an officer from November 3rd, 2023 at a MARTA station?
Guilty.
On the criminal trespass, it's 12 months to be served concurrent with the simple battery charge. On the simple battery against a police officer, your sentence is 12 months to serve 60 days, credit for time served 5 days, which means that you have 25 more days to serve at the Fulton County Jail. Do you understand?
Yes, Your Honor.
After the 25 days, you'll be released and you'll be placed on probation. You will report to the Fulton County Probation on the first available business day, and that would be at 132 Mitchell Street in downtown Atlanta. If you fail to report to probation in a timely manner, probation is authorized to issue a probation warrant, and you will be back in jail to serve out the rest of the year in a Fulton County jail. Do you understand, sir?
Say that one more time.
You have to serve 25 days at a Fulton County jail. After you are released, you must report to a Fulton County probation office at 132 Mitchell Street in downtown Atlanta. You must report on the first available business day after you are released from the jail. If you don't report to probation, we will issue a warrant for your arrest and you will be back in jail to serve out the rest of the year. Do you understand?
Yes, Your Honor.
While you're on probation, you will complete 12 anger management classes, and you must enroll in those classes within 30 days of reporting to probation. Again, you must stay away from all model bus stations and train stations. Any questions about that?
Yes.
What's the question?
Can I plead guilty?
You've already pled guilty. This is your sentence. You'll be on probation.
Yes, Your Honor.
On the third case, how do you plead to criminal trespass and violation of certain rules at a bus or rail station from January 2nd, 2024? This is your third case. How do you plead?
Guilty.
On the criminal trespass, your sentence is 12 months to serve 6 days, credit for time served 3 days. Balance suspended, again, to stay away from all model property. And your conviction for violation of certain acts at a station, that's going to be 12 months concurrent with count 1. On your fourth case, Mr. Pack, stemming from an April 24th, 2024 incident, I'm as tired as you are, but you were the one who brought all these cases to us, so I hope you're paying attention. Do you understand, sir?
Yes, Your Honor.
On this fourth case, how do you plead to criminal trespass, willful obstruction of an officer, again, violation of certain acts at a bus or rail station, and public indecency? How do you plead?
Guilty.
On this fourth case, on the criminal trespass, is 12 months to serve 30 days, credit for time served 29 days, balance probated. And again, you will be reporting to probation just as you're doing on the previous case. Again, to stay away from all model property. On the willful obstruction is going to be 12 months probation, concurrent to count 1, and to pay a $300 fine. You will begin by paying that fine with a minimum payment of $20 in the first month and $20 every month thereafter. And you'll be on active probation until all fines are paid off. On the count 3, that will be 12 months concurrent with count 1. And on count 4, that will be 12 months concurrent to count 1. So in other words, Mr. Pack, you'll be on probation for 12 months. And you have to make sure that you stay away from all model property. You will need to do 12 weeks of anger management and pay a $300 fine while on probation. Understood?
Yes.
Good. That concludes your cases. Thank you.
All right. Mr. McClain, do you have to do a breakout session with Anthony White, positions 37 and 38?
I'm sorry. Courtroom 2, could someone answer Deputy's question? Anthony White.
Yeah, I
You have
did.
to do,
All right.
you have
Miss,
to do a break.
yes. Miss Vigilante, do you have a separate device?
I do not, Your Honor.
Okay.
I'm on. I didn't sign you on if you. You have to stick it right in.
Okay. Why don't you just transfer it?
All right, let's, we have another gentleman in courtroom 2. Who is that?
Come on.
Jail court, we're going to put you in a breakout with Miss Vigilante, and hopefully she can get on a separate device.
Well, I was gonna suggest, I'm sorry, I was gonna suggest if I can just bring him down because we're losing battery power.
That would be fantastic.
Fantastic, yes.
Thank you, Deputy.
Okay.
Thank you.
Okay.
In person.
All right, courtroom 2, who do we have, please?
This is gonna be position number 1.
Thank you,
Mr.
sir.
Brown.
Okay. This is Robin Brown, accused of PI, a misdemeanor charge, and loitering or prowling from April 1st, 2024. He also has, let me see. All right, so I believe that is Mr. Brown. These are the 2 charges brought against you under case 24 CR 30058. You have been advised of your, or let me just reiterate, you do have a right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney, and Mr. McLean is representing you. Ms. Falk, what is the announcement on a transfer?
Your Honor, we did receive the transfer paperwork. I did accidentally send that to Ms. Strong instead of Miss Grace. So I am now forwarding that information to Miss Grace. We received transfer paperwork on Robin Brown, Taquan Thurman, Brandon Phillips, Deshante Phillips, and Marcus Smith. Some of these are duplicates from a previous calendar, but just in an effort to make sure everyone had it, everything, I forwarded all of the orders.
Okay. Mr. Brown, your case is going to be transferred to the Superior Court of Fulton County. And this particular case is going to be consolidated either with an open case there, or it's going to be treated as a felony matter. You may waive your right to remain silent, or rather exercise your right to remain silent and ask your attorney a question if you want to. Mr. McLean, you're free to mute your screen if you want to.
Okay, are we unmuted?
No, you're not. I can hear you.
Okay, we had planned to file a waiver of not presence, but actually the formal reading of the accusation. But we understand the transfer procedure. I'll explain that further to my client.
Okay.
If he has any further questions, you want to direct them to me or to the judge?
I'm going to talk to him.
All right, you realize this is a magistrate. May I speak? May I speak? May I? Thank you. We are in a state court. Your case is being transferred to a different.
I want to speak.
May I speak?
Yes, sir.
Okay.
All right, Mr. Brown, I've already advised you of your right to remain silent. If you decide to waive your right to remain silent, please remember statements that you make can be used against you in the prosecution of any open cases. Yes, sir.
Yeah, okay, here's the thing, is I was brought to pretrial detention center, right? April 1st, on these charges, I stayed there without seeing a judge or an attorney all the way to April 11th. And I was bound over here from pretrial and I went in front of her on April the 12th.
Can I just ask you before you continue, because I don't understand your phrases.
Okay.
Okay, you said you were bound over for pretrial. What does that mean?
Pretrial detention center, it's pretrial jail, the city jail. I was originally locked up for shoplifting on April 2nd.
You're bind over.
I was a bind over I was locked up. I wasn't arrested by the officer on these charges. I was locked up with shoplifting. And I was took to pretrial. When I got to pretrial, the officer brought a warrant and they gave me this ticket with these charges on it. And I was originally locked up with shoplifting. However, they told me I would be going to court the next day, which would be April 3rd, on these charges. I did not go. I stayed over 11 days. When I stayed over 11 days, I went to the county to ask the officer why hasn't I went to court. He stated that the officer brought the warrant, so it was not properly flagged. at that time, they had a problem finding the tracking number. They bound all the 3 charges, shoplifting and this the ticket that they gave me, which I had already been locked up at that time, 10 days without talking to an attorney or seeing any judge. I got over here on 11. I came in front of the judge on April 12th. When I got to April 12th, the judge said they had upgraded to a felony. They sent me downtown to Judge Brooks on May 6th. Judge Brooks looked at it and said it was a misdemeanor, that she could not touch it, and send it back here. At that time, I had now been locked up 52 days before I seen you.
Before what?
They bound it over to Superior Court Judge on April 12th, said it was a felony. I went to court on May 6th in front of Judge Brooks. She looked at it, said she could not touch it, that it was not a misdemeanor, and sent it back to state court on May 6th. It said it wasn't a felony. Now, all the time, I still been in jail, however, since April 2nd without seeing a judge or having a first appearance on interviews. Then she said, when I got down there on May 6th, she sent it right back to state court, which while I'm here in front of you, her supervisor said I was only come here today to address the Riverside, talking about the Riverside law, that my constitution, my First Amendment rights had been violated. This officer had been harassing me for 2 years. He same one put these charges on me last year. He stated that I did something, pulled my pants down, which they found out wasn't true. Again, I was locked up with shoplifting. He brought the ticket late. You know what I'm saying? We had a hearing. They said, did you catch? He didn't catch me at the scene. He only said he got a call saying I fit the description, that he couldn't describe what I had on at the hearing. Miss, I don't understand what's going on with her or none of them. I've been in jail since April 2nd. And this.
The charges are from April 1st, all right? So just give me a moment. Okay. So it looks like you were seen by the municipal court judge on April 3rd, 2024, according to the bind over document.
You trying to tell me again, she sent it back to her. So you see, I've been doing this.
So if you want to keep interrupting me, that's fine.
I'm sorry.
But I'm trying, number one, to figure out what you're asking for, and number two, I'm trying to corroborate what you're saying.
Your Honor, if I might summarize one point. He feels that by going back and forth to different courts that he's lost out on some Riverside days that he should have had. And if the court retains during this transfer, if the court retains any jurisdiction whatsoever over his bond, it would be good to address that today if possible. He would be telling us of a stable mail address and that he would be watching his mail like a hawk at his son's house. Sister, I'm sorry, not son. Sisters. Okay. That's all. That's the only point. I understand he's very passionate about this, which of course is understandable.
So there was a bind over on April 3rd. So he was seen by a judge within, he said he's been in jail on April 2nd, so he was seen within, so there's no Riverside with regards to that.
And Your Honor, if I may point out, if you look at the jail screen, the warrants for the PI case and for the loitering and prowling were actually logged with the jail April 12th when he was brought over here. And so those warrants were then placed on him. He then went before a judge on a first appearance on April 12th. The judge, Judge Oliver, then gave him a first appearance on that case and gave him a $15,000 good bond. So he did receive first appearances on both cases within the time frame that it would not be Riverside.
All right. Okay, so what are you asking for, Mr. Brown, at this time?
I'm telling you now, this is what I'm saying. No.
She asked you a simple question. What do you want?
This is what I want. I want to do, I'm telling her, they brought the ticket to me.
Wait.
At pretrial. Hold on.
Let me interrupt you for a second. You're going back into a narration of facts. The court asked you.
Okay, this is what I'm about to say.
Wait, the court asked you, what do you want? simply say to the court that you would like a bond reduction.
I would like to be able to
Wait.
get out of jail. man.
So that you can stay at your sister's house and watch your mail like a hawk. It's just that simple.
Okay, hold on, let me finish.
All right.
Okay, they bound the case over, I'm not trying to be disrespectful, Judge. They bound this same case over April 12th to Judge Brooks. When I went to a preliminary hearing on May 6th, because the judge upgraded to a felony. When I went to the preliminary hearing, she said she could not hear the preliminary hearing because she said it was a misdemeanor and sent it back to state court.
Your Honor, could I mute to just give him one more piece of advice?
The case, since I've already asked him, what does he want? And he still has not told me. I'm gonna ask you one last time, and then after that.
I would like to get I need a signature bond, so I can have me a lawyer. I need
Okay,
to go to my sister's house and give me a lawyer, because I've been harassed, I feel like my rights been violated, everybody lying.
TMI.
I
Just ask for the signature bond.
just want a signature bond, please.
Okay.
Please.
all right, Mr. Brown. Based on the information that I can see at the present time, I don't see a Riverside issue. So I'm going to let the charges move forward. The next question I have is whether you qualify for a signature bond. And those are going to be with the application of what we call the Ayala factors. Whether you have, whether you show any indication that you have a high likelihood of returning to court and a high likelihood of not reoffending. So Ms. Falk, presently he's got a bond, a surety bond on the two charges in this case, and he's requesting a signature bond. Any response from the state?
Your Honor, my response would be, now that Your Honor is aware that this case is a felony, Your Honor no longer has venue or jurisdiction over this
I haven't
case.
signed the transfer order yet.
I understand you haven't signed it, but the fact remains that it is a felony case. It doesn't require Your Honor to sign the order for it to be a felony case. Based on the statutory factors, it is a felony case. I will point out he has 102 cycles, and he has multiple convictions for PI, for peeping Tom, as well as for theft by shoplifting. He is a repeat offender and a recidivist in Superior Court of Fulton County, which is why both of his cases are going to the DA's office.
All right, any counter argument, Mr. McLean?
So the bond is currently, I believe, did I hear a figure of what $1,000? Was it 15?
It's a 5,500, 5,000 on the loitering and prowling. And he doesn't have a bond on the PI charge. Would you agree, Ms. Falk?
Actually, I'm looking at an order right here from dated April 12th from Judge Oliver that says there was a $10,000 bond granted on the public indecency and a $5,000 bond granted on the loitering and prowling for a total of a $15,000 surety bond. Let me just double check and make sure there are no superseding bonds, but there appear to be 2 bonds already on this case.
Okay. I can't see that order, but
I can send you the order, Your Honor.
or if you can screen share it on this, on
That would be fine as
Mr.
well.
Now, Your Honor, doing my best to advocate for him, although he may have his own ideas about what to ask for. I have a little more legal experience in courtrooms than my client does. Therefore, I would.
No, sir, let me just see the order first. That's all. Let me
All
just see the order. I can't see it there. I see no bond on the PI charge, but
I'm sending the bond order over right now, Your Honor, as well as to PD McLean, so that both of you can review it and let me know if that would be sufficient.
Is it,
I just sent.
okay. The signal is very poor in this room.
that's fine. Hang on. There we go.
All right. You per se. Oh, hey, can you mute us? All right.
All right, this was the magistrate court conducting first appearance. And this was handled by Judge Rashida Oliver, in which the bond was set at $15,000 surety. And to stay away from 745 Fountainhead Lane. And this is signed off on April 12th, 2024. All right. And the warrants appear to have been dated at that time as well. Okay. Mr. McLean, that's his current bond situation. So,
Right, and given that he's asking for a signature bond, and I can see from the recitation about the prior record that Your Honor might not be inclined in that direction for a signature bond. So I would like to just throw in there that perhaps he should ask for a bond reduction in the neighborhood of $2,000, $3,000, $4,000, $5,000. That would get him back out of the stratosphere and into an area of bond that he could possibly make. And the public, of course, would still be protected from any FTAs, because there would be quite a penalty financially were he to miss court.
you're absolutely correct, Mr. McLean. His significantly troubling criminal record history shows that he has an extremely high likelihood to reoffend. And the fact that he's claiming ignorance of these charges also doesn't help to his veracity. So the bond request modification is denied. This case is going to be transferred to the Superior Court of Fulton County. And if there is any...
Let me explain something.
No, you're done. Thank you.
I'm gonna sue
Deputy
you for lying, I'm gonna
Chairman,
sue her for lying.
Please mute the Zoom and remove him from the courtroom. All right, Mr. McLean, do you have any other clients that you have to be addressed? Mr. McLean, Ms. Vigiletti, do we have any other defendants to be addressed?
Yes, Judge. Mr. White is just about ready. I need to just ask him the questions of the plea colloquy real quick, and then he'll be ready today. That's position 26.
All right, do you have any others besides Mr. White?
I do not. That's my last client for the day.
All right, while you're wrapping up with Mr. White, Mr. McLean, I'll just go over the calendar with you, if you can take notes for Ms. Vigiletti too.
Yes, Your Honor, let's
right.
go over the calendar.
On the probation revocation calendar, sir, do you have it in front of you?
I still have Mr.
Rainwater, yes.
Rainwater, yes, Rainwater.
I don't know when he's going to be produced, but presently on position 1 and 2, Tonya Brown, probation was revoked. Position 3 and 4 is continued on probation. Position 3 and 4, Vincent Price has a third case, 23 CR 000891D, where he's also continued on probation. Position 5, 6, 7, and 8 are on hold pending production of Mr. Rainwater. On the add-on case, Mr. Robin Brown, both these cases are going to, and position 1 on the SAP calendar, both are going to be transferred to the Superior Court as felony matters. Bond modifications have been denied. Position 1 on the SAP calendar is transferred to Superior Court. Position 2 was a plea. Position 3, Ellington, was a plea. Position 4, Abraham Harris has refused to be interviewed, and a negotiated offer needs to be discussed with him, but he refuses to come. So his case is reset to May 30th. Position 5, 6 were pleas. Position 7, 8, 9 is a waiver of arraignment and further notice for trial, including the 4th case listed on position 9, which is 24 CR 1899G. Position 10, Vernon King. Is this case going to be transferred?
No, Your Honor, state didn't request a transfer on this case.
Okay, so we're going to reset this to May 30th.
Well, this is a time served plea, Your Honor. So out of curiosity, is the jail able to bring Mr. King down? Has he been released? What is his current
I
status?
have associated felony charge, documentation needed. Defendant has no memory of the incident. Or maybe, or is that for a different?
Judge, I'm sorry to interrupt. If we're talking about Vernon King,
Yeah.
he is being held on a felony. He will be held until at least June 3rd, and I do need to speak. This case is associated with the felony, so I do need to speak to the felony attorney before we can address it.
Okay, that's what your notes meant. Okay, all right. So that case, Vernon King is reset to May 30th. Okay, so going back to position 11, Alexis McPherson is reset to May 30th. And that's the one where she has to be, where PD Vigilante needs additional information to refresh her client's memory of this incident.
That is correct, Your Honor.
All right, position 12 is reset to May 30. No, well, I'm just going to reset it to May 30th, pending a transfer to the DA's office, which has been confirmed. Position 13, 14, 15, and 16, Kenneth Pack will please. Position 17, Shakab Patterson is reset to Tuesday, May 28th for private counsel to appear and confer with his client. Position 18, Victor Payton is a plea. Position 19, Brandon Price.
He's here, Your Honor. I believe that's Mr. Price on the medical screen.
Okay, we will address him shortly. Position 20, Tamarius Ray was a plea. Position 21, Baxter Ross. Is this going to be a waiver of arraignment, Ms. Vigilante?
I'm sorry, Judge.
Number 20, what's in there?
Waiver, Baxter
21.
Tommy Ross.
Baxter, 21.
Yes, I've sent over a waiver of his presence and arraignment, and he's entering a not guilty plea today.
All right, this is going to be further notice for trial. Position 22, and that is Yamini Somasundram. Position 22 and 23, Mr. Somasundram was released, so that's further notice for trial. Position 24, Brandon Spear was a plea. 25 is null frost. 26, Anthony White is, we're going to be addressing that shortly. Position 27, 28, 29, 30, and 31, Jennifer Wilkie. Is this our waivers of arraignment and further notice for trial? Position 32, Barnago Williams. So 20 was a plea. 33 is null frost. 34, Ricky Williams is reset to May 30th to get a better understanding of his plea. Position 30, excuse me, I'm so sorry. 34 is reset to May 30th. 35, Dontavius Wright, and that is Mr. Michael McLean. 34 and 35. These are going to be a waiver of arraignment and further notice for trial. 37, William Wright. Have we addressed it?
Let's see. I don't believe we've addressed William Wright.
All right. So 37 and 38 are still a question mark. All right. Position, Mr.
Position 37 and 38 is right here in medical, Mr. Williams.
Okay. Where is Brandon Price then? Position 19.
He's right here.
Okay, so the person seated in the chair at medical is Mr. Wright. Would that be correct?
That's
Correct.
William Wright. I misspoke. I said it was Mr. Price. That is Mr. Wright sitting there.
Okay, no problem. Okay, so we are addressing positions 37 and 38. And this is William Trayvon Wright, case numbers 22 CR 5205F, in which he's accused of simple battery family violence from August 3rd, 2022 And position 38, Mr. Bright, this is a bench warrant, 24 FTA 552. You have a right to remain silent, Mr. Wright. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. May I place you under oath for purposes of your plea?
Yes, ma'am.
Mr. Wright, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mukherjee, what is the recommendation for position 37?
Yes, Your Honor, the recommendation for position number 37 is 12 months probation, serve 40 days, credit for time served 20 days, and that is for August 4th, 2022 to August 5th, 2022, and then May 6th, 2024 to present, balance probated FVIP, 40 hours community service, and no further violent contact with the victim, Ms. Ebony Rhodes. At this time, I would sound for the victim, Ms. Rhodes, and also ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea, and for the FTA, we will be no crossing.
Yes, we do so stipulate for the purposes of the plea.
All right. Mr. Wright, have you consumed any medicine or alcohol? If we could unmute medical, please.
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you, inducing you to take this plea offer today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to come back to court and with your attorney to confront your accuser, challenge the evidence brought against you, present your own defenses, arguments, and mitigating factors if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery family violence from August 3rd, 2022?
I'm sorry, can you repeat that one more time?
How do you plead to one count of simple battery family violence?
Guilty.
Repeat.
Say guilty.
With regards to your plea, before I impose your sentence, I see that Ebony Rhodes, I saw her on Zoom. Miss Rhodes, did you want to say anything before I impose a sentence, Mr. Wright?
Yes, ma'am. I just,
Please start your video.
I'm sorry. It says that the host has disabled it.
Mr. Strong, if you can prompt a start video for Miss Rhodes.
Okay.
All right. Yes, Miss Rhodes, what would you like to say?
I just wanted to address the court on this issue and state that I have not had any violent or any type of incident with Mr. Wright since the incident. Furthermore, through a third party, I have gained a better relationship and understanding with him, and I have a very good relationship with his daughter, and I'm just hoping that he can, you know, hurry up and get out, because at this point in time, his daughter really needs him right now, and this situation is causing a big strain on his minor daughter, and it's affecting her very much.
Thank you. All right, Mr. Wright, with regards to your guilty plea and also taking into account what Ms. Rhodes has indicated, your sentence is going to be 12 months to serve 40 days, credit for time served 20 days. Your jail time is completed, and if you have no other cases holding you at the jail, you will be released within 24 hours. Your remainder of your 12 months will be served on probation. You will report to probation next Tuesday, May 28th, 2024, and that would be before 3 p.m. Your probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll and complete a domestic violence intervention program. That is a 24-week program, which you would have to complete at your expense. You must enroll in those classes within 45 days of being released, and you must continue with those weekly classes without any breaks at your expense. You will also complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. You will begin with completing a minimum of 5 hours in the first month and a minimum of 5 hours thereafter to the completion of 40 hours of voluntary service. At all times while you're on probation, you shall have no violent contact with Ebony Rhodes. In other words, you can have contact with Ebony Rhodes, but it cannot involve any physical or verbal altercations that may require police to be involved. Do you understand, sir?
Yes, ma'am.
All right, that completes your sentence. Thank you.
Thank you, Your Honor.
Who do we have at medical?
Position number 5 and 8 through 8, Rainwater on probation.
And just for Mr. Wright, his bench warrant is null prost. Thank you. Miss Allen? Okay, she's present. Good. All right, thank you. We are addressing Daylon Rainwater. Mr. Rainwater, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean, who is presently situated in courtroom 2. Do you see him on the screen?
Yes, ma'am.
All right. Mr. Rainwater has 4 open matters with on the probation revocation calendar. He has convictions in 2 separate cases. The first one is 22 CR 6351F, in which he is convicted of 1 or more of the following charges: public drunkenness and 4 counts of willful obstruction of a law enforcement officer. In the second case, 23 CR 4120F, he is convicted of theft by shoplifting. The other 2 cases are his revocation cases, 24 PV 841 and 24 PV 842. Mr. Rainwater, probation officer, Ms. Allen, is going to indicate the reasons why probation is seeking and what is their recommendation. Can you hear us all right?
Yes, ma'am.
Okay. Ms. Allen will need to speak up in order to compete with the noise in that location.
Okay, on case number 22 CR 6351F, the defendant was sentenced to probation for a total of 12 months, where he was required to complete a drug and alcohol evaluation and 30 hours of community service. As of today, the defendant has failed to provide our office with the community service completion. He's failed to report. He's failed to complete the substance abuse evaluation. On that particular case, is 208 days remaining. We are asking for the defendant to be allowed to continue on probation to satisfy the conditions of probation.
All right. And what about the theft by shoplifting conviction?
Your Honor, he was required to complete the shoplifting course. As of today, the defendant has failed to provide our office with the course completion. It is 211 days remaining on his case. At this time, we ask for him to be allowed to continue on probation and complete that shoplifting course.
All right. Mr. McLean?
He agrees with recommendations. If given the second chance, he will complete those matters.
Does he have any other holds at the jail?
Not, I cannot see that. Mr.
I'm trying to see whether he was arrested on the outstanding probation warrant or whether he had a new case.
Your Honor, I'm pulling it up now.
Dayton or Daly?
He has 2 probation violations.
So that's it. Apparently that's it, just these.
Okay.
Yes, that is it, Your Honor. He has been in custody since May 14th.
Thank you. I will allow him to be continued on probation. I'll give him credit for the time that he's been in custody since May 14 to the present time. So that would be a credit of 9 days.
That is wonderful, Your Honor. He's got a restaurant job he's anxious to get back to, and he's going to do this probation right.
Well, before we let the horse out of the barn, he needs to listen to this. He will report to probation next Tuesday, May 28th, before 3 p.m. If he fails to report, he will be back in jail. He will continue on probation for the remainder of the $11 days, less than 9 days. He has 202 days left to serve on probation. He will report to probation twice a month. So the first report date is May 28th before 3 p.m. And then thereafter, it will be twice a month. He will complete the anti-theft class within 30 days from today. Mr. Rainwater, your options have become very, very small now. You are required to report to probation twice a month. You're required to complete the anti-shop theft class or anti-shoplifting class within 30 days from today. You're also required to complete the alcohol and drug evaluation and submit to any treatment within 30 days from today. You are to complete your 30 hours of community service with any nonprofit agency that is not a church and not a school. And you must complete at least 10 hours every month, a minimum of 10 hours every month. If you have completed the alcohol and drug evaluation, you have completed the 30 hours of community service, and you have completed the anti-theft class, then your probation will be modified to once a month. But until then, you have to report twice a month. Do you understand, sir?
Ma'am, yeah, ma'am.
All right. If you fail to report twice a month, if you fail to complete your alcohol and drug evaluation, and a minimum requirement for your community service or the anti-theft class, probation is authorized to issue another probation warrant for your cases. Thank you.
Next, position number 19, Ms. Brandon.
Your Honor, that concludes my business. May I be excused?
Yes, Miss Allen. Have a great weekend. Thank you. A
Thank
long
you.
weekend, from what I understand.
Very long, very long.
Thank you. Okay. Okay, position 19, and that would be Mr. McLean's client, Brandon Price. Would that be correct?
Yes, Your Honor. Our understanding is the state says it's still waiting on word from.
All right.
He would really like something to be able to happen today, if possible, on his bond, if he's not going to be able to take a plea here today.
All right.
And Your Honor, the state did reinitiate contact with the DA's office in regards to this case. He's currently being held on a $1,500 surety bond on the one count of criminal trespass. I will state there was an ag stalking count. The case was transferred with no explanation as to why. And so there have been a number of transfers of this nature where the state doesn't have an explanation as to why the case was transferred, only to find out later that the DA's office still wants to retain the case. And so that's why we've reached out to them to get some clarification on why the transfer was.
Mr. Price, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean is representing you. I understand that there was a bond modification already to $1,500 surety. So, Mr. McLean, what others are we addressing?
Your Honor, because he's not able to take a plea today, he's anxious to get on. Anxious is probably the wrong word. Concerned. He would like to be able to resolve his matters. Because he cannot resolve anything today, he would like to ask the court to let him have a signature bond, and he'll watch his mail and come to court.
Ms. Falk, other than the aggravated stalking, is there any other reason why the bond should not be modified?
Your Honor, that is the reason the bond should not be modified again. I will say that the defendant also has, let's see, over 25 cycles in total. I can go through those briefly with Your Honor.
Just the recent ones, just in the last 5 years, if any.
So in the last 5 years, the defendant has had, let's see, So of those cycles, the last 5 years were cycles 19 through 25. 2018 criminal damage to property in the second degree. It was not presented to grand jury by the DeKalb County District Attorney's Office. 2018 probation violation where he received 6 months of confinement from the Cobb County Superior Court. 2020 probation violation, which looks like it was dismissed. 2021 simple battery, criminal trespass, defendant pled guilty in the Cobb County State Court. 2021 failure to appear out of Cobb County. 2022 probation violation out of the Cobb County State Court, received 5 months, served 30 days on a probation violation. 2022, it looks like probation violation where the defendant received 10 days confinement. 2024 criminal trespass from MARTA Police Department that was dated January 1st, 2024, and a April 2024 arrest for possession and use of drug-related objects. And then this April 11th, 2024 criminal damage to property degrees in the second degree aggravated stalking, which was moved down to a criminal trespass and sent down to our office. So those are his most recent cycles.
All right, thank you. Mr. Price, I am very concerned considering that there is a active TPO with regards to Tina Ashgar, and I'm reading the warrant. And given the nature of your criminal record history in just this recent past, the $1,500 bond is more than reasonable in light of your alleged threat to not only the community, but to the alleged victims in this particular case. Your bond modification request, your second request for bond modification is denied. You're not being held because of whatever is going on in Superior Court. You are being held on a $1,500 surety bond simply because of the allegations in this case, given your criminal record history and application of the ALF factors. This is a reasonable bond. You don't qualify for a signature bond. Thank you.
Next, Your Honor, we're going to go to position number 26, Mr. Anthony White in courtroom
Right.
2.
In the meantime, with regards to Mr. Price, Ms. Folk, I'm going to reset this to May 20, well, it has to be May 30th. Unless, Mr. McLean, you are planning to file a waiver of arraignment?
No, Your Honor.
All right, so we'll reset it to May 30th. Please get a better certainty as to the Superior Court charges because I'm not seeing them as an open case. Like I said, the bond is not I'm completely disregarding what's going on in Superior Court with these open charges, if they exist. His bond is being set solely on the parameters of his misdemeanor case. Okay?
Yes, Your Honor.
So this is being reset to May 30th for either a plea or an arraignment. Thank you. All right. I'm sorry, Ms. Vigiletti, could you refresh my memory on position 26, was it?
Yes, Your Honor. This is Mr. Anthony White.
Okay. Mr. Anthony White is accused of battery of a certain nature, which we're not going to sound out, on case 24 CR 2906C. This stems from a May 5th, 2024 incident. Mr. White, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is representing you. It looks like there's been an offer. How is your client proceeding today, Ms. Vigiletti?
Judge, Mr. White would like to enter a plea today.
All right. Mr. White, if you've decided to accept the plea offer with the assistance of counsel, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Are you familiar with the entire charge that's been brought against you? Has your attorney shown it to you?
Yes, ma'am.
Okay, you may put your hand down, sir. Thank you. Ms. Mukaki, we shall refer to the acronym SDET and waive sounding on the charge, please.
Yes, Your Honor. The state's recommendation is 12 months probation, serve 60 days, credit for time served 16 days, and that is from May 5th, 2024 to present, balance probated, no further contact with the victim, Ms. Amina Abbasi, stay away from Grady Memorial Hospital except for medical necessity, SDET, 40 hours of community service. At this time, I will sound for Ms. Amina Abbasi and also ask that the defense stipulate to venue, factual basis, and identification for purposes of the plea.
All right. I don't see a Zoom panel with that individual. We did have someone with the name N, but I don't know if that was her. So, Ms. Vigiletti, does the defense still stipulate?
We do, Your Honor, for the purposes of the plea.
All right. Mr. White, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to having a trial before a judge or a jury in the future. You will not be able to go back to court with your attorney to confront your accuser, to challenge the evidence or witnesses brought before you, to present your own defenses, arguments, and mitigating factors if you choose to do so, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering your plea to this charge freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to the one count of battery of a particular nature?
Guilty.
Your sentence is going to be 12 months to serve 60 days, credit for time served 16 days. You have additional time to serve at the jail. Once I can take your case up next week if you want to be serious about this.
Your Honor, if I may, Mr. White is not trying to be disrespectful. He does have a diagnosis that results in.
Okay, that case.
Yes.
As I was saying, it's 12 months to serve 60 days, credit for some time served 16 days. If we deduct 32 days from 60 days, that should tell us how much time he has got left. I believe it'll be either 28 days or 14 days. Ms. Vigiletti?
Yes, Judge, I believe there's 14 additional days here.
Okay. After he has served the additional 14 days, he must then report to the probation office at 132 Mitchell Street in downtown Atlanta. That report date will be on the first available business day after his release. While he's reporting to probation, he will enroll in an SDET program, and his probation officer will go over that program with him. He must enroll in that program within 60 days of being released. He must also complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. Whichever nonprofit agency he goes to, it must not have the presence of any minors. So anyone who is under the age of 17, he cannot go to that nonprofit agency. So probation, please make a note of that. While he's reporting to the nonprofit agency, he will complete 40 hours of community service, and he must begin with a minimum of 5 hours per month and 5 hours every month thereafter. At all times, he is to have no contact with Amina Abbasi, and he is to stay away from the Grady Hospital complex at 80 Jesse Hill Jr. Drive, unless he's got a medical appointment or unless he's seeking emergency medical treatment. He will report to probation every month until the conclusion of the remainder of 12 months of probation. That concludes the sentence. Thank you.
Thank you, Your Honor.
So I'm saying, how many days do I have to do it here?
14, just like
14.
we talked about. Yeah.
All right, Ms. Vigiletti, I believe that completes the calendar. Anything else?
Good.
No, Your Honor,
That's
thank
everything.
you.
All right, you both have a great weekend. Be careful out there.
All right, you too.
Thank you. Have a good holiday.
You too, sir. All right, anyone else who's not involved in the 11 o'clock competency calendar, you're free to go. If I don't see you before then, enjoy your Memorial Day weekend. Be careful. Okay, Ms. Strong, can you place me, Ms. Falk, Ms. Burgess?
Pretty much everybody that's left.
Well, no.
It's-
Yeah,
I got-
Kamsha, And I don't think Miss Thomas wants to join us for a,
No, ma'am. Everybody else, one moment, Judge.
yeah, anyone who needs to be in the competency breakout, please start your videos so Miss Strong can place us in the breakout. Thank you.
And Kia's on, Judge.
We can pause the